1. What do you understand by Civil Procedure Code? Give brief history of Code of Civil Procedure and briefly discuss some of the important changes made by Amendment Act No. 22 of 2001 in Civil Procedure Code. Ans. Laws can be divided into I. Substantive law or 2. Adjective or procedural law. Substantive law provides for rights and liabilities of the parties, whereas adjective or procedure law prescribes the practice, procedure for enforcement of those rights and liabilities. Indian Contract Act, Transfer of Property Act, Industrial Dispute Act are examples of substantive law, while Indian Evidence Act, Indian Limitation Act or Code of Civil Procedure are instances of procedural law. Main object of any procedural law is to facilitate the court in enforcing the rights and liabilities of parties in due compliance of natural principles and established procedure. Aim of Civil Procedure Code. The aim of the procedural laws is to implement the substantive laws effectively, and, therefore, Civil Procedure Code has been enacted with the object to provide fair justice without any delay. The ultimate aim of the code is to provide simple and expeditious procedure for doing justice between the parties. It has been framed to provide uniform procedure so as to avoid diversity in the manner of dealing with cases before the courts. Therefore, provisions of Code of Civil Procedure must be interpreted liberally so as to subserve and advance the cause of justice. In State of Punjab v. Shamlal Murari, AIR 1976 SC 1177, Krishna Iyer J. has observed, "We must always remember that procedural law is not to be a tyrant but a servant, not an obstruction but an aid to justice." It has been wisely observed that procedural prescriptions are the handmaid and not the mistress, a lubricant, not a resistant in the administration of justice. Where the non-compliance, the procedural, will thwart fair hearing or prejudice doing can be corrected without injury to a just disposal of the case, we should not enthrone a regulatory requirement into a dominant desideratum. After all, courts are to do justice, not to wreak this end product on technicalities. History of Code. Before 1859 there was no uniform code of civil procedure. There were different systems of civil procedure in different parts of the country. First Uniform Code of Civil Procedure was enacted in year 1959. But that code was not made applicable to Supreme Court in the presidency towns and to presidency small cause courts. Some amendments were made therein and the code was applied to whole of British India, but there were many defects in it and therefore a new code was enacted in 1877. Latter Law Commission in its various reports made many recommendations for fair trial in due compliance of acceptance of principles of natural justice and for expediting the disposal of suits and also avoiding undue complicated procedure in disposal of suit. Keeping in view the above said broad principles, in the year 1908, present Code of Civil Procedure was enacted. Then in year 1976, some important amendments were made in the code which are following. A. The doctrine of res judicata was made more effective. B. The powers to transfer proceedings from one high court to another was given to Supreme Court. C. Freedom from attachment of portion of salary to all salaried employees is granted. The provision of giving notice under Section 80 before institution of suit against the government or a public officer was made less stringent. The scope of summary trials was widened. F. Important changes were made to provide relief to poor section of the community. Important amendments of Act of 2000 to Act number 22 of 2002 has been passed for amendments of Code of Civil Procedure so as to expedite the disposal of suits and to avoid time-consuming complicated procedural formalities. Some of the important amendments are: Section 100- has been added which provides that notwithstanding anything contained in any letters patents for any high court or in any instrument having force of law or any other law, where any appeal from a original or appellate decree or order is heard and decided by single judge of a high court, no further appeal shall lie from judgment and decree of such single judge. 2. Section 102 has been amended and which has permitted the filing of second appeal if subject matter of suit for recovery of money is not exceeding 2,500 rupees. Amendment made in Order 7, and it is made obligatory for defendant to present his written statement within 30 days from date of service of summons to him. If he fails to do so, court may, for reasons to be recorded, allow him to present written statement on any other date, but not later than 90 days from date of service of summons. 4. Amendment in Order V of Code is made and provisions of service of summon through duly approved courier service or by fax message or electronic mail are made. Amendment is made in Order 6 Rule 17 and now no application for amendment of pleadings shall be allowed after the trial has commenced unless court has came to conclusion that in spite of due diligence, party could not have raised the matter before the commencement of trial. 6. Amendment is made in Order 18 and provision has been made in Rule 4 for recording the examination in chief of witnesses in a suit by affidavit, copies of which will be supplied to opposite party. Q. To distinguish between decree and order. Ans. Decree, Section 2. Decree means formal expression of an adjudication which so far as regards the court expressing it, conclusively determines the rights of parties with regard to all or any of the matter in controversy in suit and may be either preliminary or final. It shall be deemed to include the rejection of plaint and determination of any question within the Section 144 but shall not include a. Any adjudication from which an appeal lies as an appeal from an order. b. An order of dismissal for default. Explanation: decree is preliminary when further proceeding have to be taken before the suit can be completely disposed of. It is final when such adjudication completely disposes of the suit. It may be partly preliminary and partly essential elements. There must be adjudication. 2. Such adjudication must have been given in a suit. 3. It must have determined the rights of parties with regard to all or any of the matters in controversy in suit. 4. Such determination must be of conclusive nature. There must be a formal expression of such adjudication. Classes of decree. Primarily, there are two kinds of decree. I. Preliminary decree. 2. Final decree. Preliminary decree, where an adjudication decides the rights of the parties with regard to all or any of matter in controversy in suit but does not completely dispose of the suit. It is a preliminary decree. Explanation added to Section 2 also says decree is preliminary when further proceedings have to be taken before the suit can be completely disposed of. CPC provides for passing preliminary decree in following cases. 1. Suit for possession and mesne profit, O 20R 12. 2. Administration suit, O 20R 13. 3. Suit for preemption, O 20R 14. 4. Suit for dissolution of partnership form, O 20R 15. 5. Suit for accounts between principal and agent, O 20R 16. 6. Suit for partition and separate possession, O 20R.18. 7. Suit for foreclosure of mortgage, O 34R 223. 8. Suit for sale of mortgaged property, O 34R 425. 9. Suit for redemption of mortgage, O 34R 7-8. Question whether decision amounts to preliminary decree or not is a great significance in view of Section 97 CPC, which provides where any party aggrieved by preliminary decree does not appeal from such decree, he shall be precluded from disputing its correctness in any appeal which may be preferred from final decree. Final decree. A decree may be said to final in two ways. I. When within prescribed period no appeal is filed against the decree or the matter has been decided by decree of the highest court. 2. When the decree, so far as regards the court passing it, completely disposes of the suit. Normally, final decree is construed which, so far as the court passing it, finally dispose of the controversy involved and the suit. Order. Section 2(14). Order means the formal expression of any decision of civil court which is not a decree. Section 2(14). Thus, the adjudication of a court which is not a decree is an order. Decree and order. Distinction. The adjudication of court of law may either be decree or order. Fundamental distinction between two are: A. Decree can only be passed in a suit which commenced by presentation of plaint. An order can be passed in suit by presentation of plaint or may arise from proceeding commenced from application. B. Decree is an adjudication conclusively determining the rights of parties with regard to all or any of the matter in controversy. Order, on the other hand, may or may not finally determine such rights. C. Decree may be preliminary or final, but there cannot be preliminary order. D. Except in certain suits in which two decrees, i.e. one preliminary and one final, is passed, there can be only one decree, but in suit or proceedings there can be number of orders. D. Every decree is appealable unless otherwise expressly provided, but every order is not appealable. Only those orders are appealable as specified in code. Q3. What is the effect of reversal of the preliminary decree on the final decree passed by the lower court during the pendency of appeal against final decree? Ans. The effect of the reversal of the preliminary decree on the final decree passed by the lower court during the pendency of the appeal against the preliminary decree is that the final decree is superseded because the final decree is its nature dependent and subordinate, as it is a decree which has been passed as a result of proceeding directed and controlled by the preliminary decree and based thereon. Therefore, when a preliminary decree is set aside, the final decree is automatically superseded, whether the appeal was brought before or after the passing of the final decree. In Seetal Parshad v. Kishori Lal, AIR 1967 SC 1236, it was observed by Supreme Court that since the passing of preliminary decree is only a stage prior to the passing of final decree, if an appeal against a preliminary decree succeeds, the final decree automatically falls to the ground, for there is no preliminary decree thereafter in support of it. Q4. Are the following orders amount to decree within the meaning of Section 2(2) of Code? A. An order rejecting a memorandum of appeal insufficiently stamped. B. Memorandum of appeal which is dismissed as time-barred. C. An order returning a memorandum of appeal for amendment. D. An order that a suit abates. Ans. Section 2(2) of Code defines the term decree as: decree means the formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the right of the parties with regard to all or any of the matters in controversy in the suit, and may be either preliminary or final. It shall be deemed to include the rejection of plaint and termination of any question within Section 144, but shall not include: A. Any adjudication from which an appeal lies as an appeal from an order, or B. Any order of dismissal for default. Keeping in view the above definition, let us assess whether following are decree or not. A. An order rejecting a memorandum of appeal as insufficiently stamped is not decree because said order is not appealable and fresh memorandum of appeal with requisite stamp may be filled. B. Dismissal of appeal being barred by limitation is decree, as a court dismissing it, even on the ground of limitation, is finally disposing of the matter. Such order is appealable as decree. C. Order returning memorandum of appeal for amendment is not decree because such order does not finally dispose of the matters so far as the court passing such order. D. An order that suit abates is a decree. Q5. Can an appeal against final decree correctness of the preliminary decree be questioned when no appeal has been preferred by aggrieved party against the preliminary decree? Ans. Section 97 of Code of Civil Procedure Code give answer to this, which provides that whether any party aggrieved by a preliminary decree does not appeal from such decree, he shall be precluded from disputing its correctness in any appeal which may be preferred from the final decree. So, in view of Section 97, in an appeal against final decree, correctness of preliminary decree cannot be challenged in the absence of any appeal against preliminary decree by aggrieved party. Q6 define and write short notes on A. Masonry profits. B. Foreign judgment. C. Judgment debtor. D. Decree holder. E. Ex parte decree. F. Legal representation. Ans. A. Masonry profits section 2:12 of Code says Masonry profits of property means those profits which the person in wrongful possession of such property actually received or might with ordinary diligence have received therefrom, together with interest on such profits, but shall not include profits due to improvements made by the person in wrongful possession. The right to possession is a sacred right guaranteed to all law-abiding citizens. When a person is deprived of his possession, he is not only entitled to recover possession but also damages for wrongful possession by another. The Masonry profits are a compensation, which is penal in nature. The object of awarding a decree for Masonry profits is to compensate the person who has been kept out of possession and deprived of enjoyment of his property. Thus, wrongful possession of the defendant is the essence of a claim for men's profits. In Fateh Chand v. Bal Kishan Das, AIR 1963 SC 1405 it was observed that Masonry profits being in the nature of damages, no invariable rule governing their award and assessment in every case can be laid down, and court may mold it according to justice of the case. However, following principles would ordinarily guide a court for determining the amount of Masonry profits. I. No profit by a person in wrongful possession. 2. Restoration of status before dispossession of decree holder, and 3. Use to which the decree holder would have put the property if he himself was in possession. B. Foreign judgment section 2:5 of Code has defined foreign court as a court situated outside India and not established or continued by the authority of the central government. Similarly, section 2:6 say foreign judgment means a judgment of a foreign court. In Shitol v. Sankasaran, AIR 1962 SC 1737, it was observed that crucial date to determine whether the judgment is of a foreign court or not is the date of the judgment and not the date when it is sought to be enforced or executed. So a judgment of a foreign court at the time of its pronouncement would not cease to be foreign judgment by reason of the fact that subsequently the foreign territory has become part of the Union of India. C. Judgment debtor. Section 2:10 of Code of Civil Procedure says, judgment debtor means any person against whom a decree has been passed or an order capable of execution has been made. Where the decree is passed against a surety, he is a judgment debtor within the meaning of this section. On the other hand, a person who is a party to the suit, but no decree has been passed against him, is not a judgment debtor. D. Decree holder. Then section 2:3 of Code defines decree holder as decree holder means any person in whose favor a decree has been passed or an order capable of execution has been made. From this definition, it is clear that the decree holder need not necessarily be the plaintiff. A person who is not a party to the suit, but in whose favor an order capable of execution has been passed is also a decree holder. E. Ex parte decree. Order 9 Rule 6 of the Civil Procedure Code provides that where the plaintiff appears and the defendant does not appear when the suit is called on for hearing, then if it is proved that the summons was duly served, the court may make an order that the suit be heard ex parte. Ex parte means in the absence of the other party. Ex parte decree can be passed only after the date of the first hearing fixed in the summons, and not before that. The order to proceed ex parte can also be passed if the defendant, after putting his appearance after service of summons, remains absent on the date of hearing subsequent fixed. Even if the court proceeds ex parte, it has to act according to law, and the plaintiff must prove his case. F. Legal representative. The term legal representative has been defined in Section 2(11) of the Civil Procedure Code. According to it, legal representative means a person who in law represents the estate of a deceased person, and includes any person who intermeddles with the estate of the deceased and where a party sues or is sued in a representative character, the person on whom the estate devolves on the death of the party so suing or sued. The above definition is not exhaustive, but illustrative. In order to be a legal representative under Section 2(11), it is not necessary that a person should be a legal heir of a deceased person or that he should have a beneficial interest in the estate. Q7. What do you understand by the term jurisdiction of a court? Ans. Term jurisdiction may be defined to be the power or authority of a court to hear and determine a cause, to adjudicate and exercise any judicial power in relation to it. So jurisdiction is meant the authority which a court has to decide matters that are litigated before it or to take cognizance of matters presented in a formal way for its decision. There is always a distinction between want of jurisdiction and irregular exercise of it. The defect of jurisdiction goes to root of the matters. Such a basic and fundamental defect cannot be cured by consent of parties. In short, a decree passed by a court without jurisdiction is a coram non judice. In Kiran Singh v. Chaman Paswan, AR 1951 SC 340 it was observed. It is a fundamental principle well established that a decree passed by a court without jurisdiction is a nullity and that its invalidity could be set up whenever and wherever it is sought to be enforced or relied upon, even at the stage of execution and even in collateral proceedings. A defect of jurisdiction strikes at the very authority of the court to pass any decree, and such a defect cannot be cured even by consent of parties. Kinds of jurisdiction. Jurisdiction of a court may be classified into the following categories. I. Territorial or local jurisdiction. Every court has its own local or territorial limits beyond which it cannot exercise its jurisdiction. These limits are fixed by the government. The district judge has to exercise jurisdiction within his district and not outside it. The High Court has jurisdiction over the territory of the state within which it is situate and not beyond it. Again, a court has no jurisdiction to try a suit for immovable property situated beyond its local limits. 2. Pecuniary jurisdiction. Section 6 of Code provides that a court will have jurisdiction only over those suits, the amount or value of the subject matter of which does not exceed the pecuniary limits of its jurisdiction. Some courts have unlimited pecuniary jurisdiction, e.g. high courts and district courts have no pecuniary limitations. But there are other courts having jurisdiction to try suits up to a particular amount of subject matter. 3. Jurisdiction over the subject matter. Different types of courts have been allotted different type of work by different statutes. For example, a small cause court can try only certain suits, such as money suit, based on an oral loan or a bond or promissory note, a suit for price of work done, a suit for recovery of price of goods supplied, but it has no jurisdiction to try the suits for specific performance of contracts, for injunction, for a dissolution of partnership, or suit for partition of immovable property. Similarly, only district judge has the jurisdiction in respect of testamentary matters, such as granting probate or letter of administration, and divorce cases. 4. Original or appellate jurisdiction. The jurisdiction of a court may be original or appellate. For example, the jurisdiction of the Court of Munsif and Small Cause Court is only original, while the Court of Civil Judge, District Judge, and High Court also exercise appellate jurisdiction. In the exercise of its original jurisdiction, a court entertains original suits, while in the exercise of its appellate jurisdiction, it entertains appeals. Q8 discuss with the help of decided cases that every kind of dispute is not entertainable by civil court. Or, what is a suit of civil nature? Give few examples. Ans. Section 9 of Civil Procedure Code confers the power upon the civil court jurisdiction to try suit of civil nature. Section 9 provides, the courts shall, subject to the provisions herein contained, have jurisdiction to try all suits of a civil nature excepting suits of which their cognizance is either expressly or impliedly barred. Suit of civil nature. The word civil has not been defined in the code. But according to the dictionary meaning, it pertains to private rights and remedies of a citizen as distinguished from criminal, political, etc. Thus, a suit is of civil nature if the principal question therein relates to the determination of a civil right and enforcement thereof. It is not the status of the parties to the suit, but the subject matter of it which determines whether or not the suit is one of a civil nature. The expression suit of civil nature will cover private rights and obligations of a citizen. Political and religious questions are not covered by that expression. A suit in which principal question relates to caste or religion is not a suit of a civil nature. But if the principal question in the suit is of a civil nature, the right to property or to an office, and the adjudication incidentally involves the determination relating to a caste question or to religious rites and ceremonies, it does not cease to be a suit of a civil nature, and the jurisdiction of a civil court is not barred. Explanation 1 to Section 9. Explanation 2, added by the Amendment Act, 1976, further provides that it is immaterial whether or not any fees are attached to the office referred to in Explanation I or whether or not such office is attached to a particular place. Thus, in order to fall within the purview of the term of civil nature, the suit must be for the enforcement of private rights and obligations of a citizen, and not of matters which are purely social. In view of Section 9 of the Code of Civil Procedure, the enquiry of the court should be confined to the dispute of a civil nature. Any dispute which is not of a civil nature should be excluded from consideration. The dispute as to right of worship is one of a civil nature within the meaning of Section 9 of the Code, and a suit is maintainable for the vindication or determination of such a right. District Council of United Basel Mission Church and others v. Salvador Nicolas Matlas and others, 1988, to SCC 31. The right to remain in the community or to exercise the rights and privileges of the members of the community is a civil one. Mansoor Ali v. Tayyibali Muhammad Ali Daudi Bohra, 157 I 302. A suit to establish a person's right to enter a religious place and a suit to restrain the defendant from entering a place of worship are both entertainable, being suits of a civil nature. It is a civil right of every citizen that he should be entitled to carry on his worship in any method he likes so long as he does not, by his performances, affect others injuriously. Where the plaintiffs claimed to be entitled to enter the temple bareheaded and worship, it was held that the civil court has jurisdiction to entertain it. Ratan Singh v. Bali Ram, AIR 1952, Punjab 163. The right to take out a procession through the public streets is a civil right, and a suit will lie to enforce such a right in a civil court. Sangana Basaswamy Guru v. Baburao Ganesh Kulkarni, ILR, 1946, Bomb. 437. The right to officiate as a priest or as a guru simpliciter is not a civil right, and no suit lies to enforce the same. But where it amounts to an office attached to an institution such as a temple, it has been recognized as a civil right. The fact that there are emoluments of a non-gratuitous character payable out of the funds of the institution is relevant, though the absence thereof is not decisive. There may be offices without emoluments at all. The crucial test in determining whether a claim to purohitship or priesthood of a temple is a claim to an office or not is whether there are duties attached to purohitship which are enforceable by law, custom or usage, whether by deprivation or other temporal sanction. Chunnu Dutt Vyas v. Babu Nandan, AIR 32 all 527. Cognizance not barred. Section 9 CPC provides that civil court has jurisdiction to entertain suit of civil nature unless its cognizance is barred either expressly or impliedly. Cognizance expressly barred. A suit is said to be expressly barred when it is barred by any statute for the time being in force. Cognizance impliedly barred. A suit is said to be impliedly barred when it is barred by general principles of law. For example, where a specific remedy is given by a statute, it thereby deprives the person who insists upon a remedy in any other form than that given by the statute. Q9 Whether following suits are cognizable by civil court. A. Suit for dismissal from post of honorary secretary of an association. B. Suit for exclusion of a member from caste. C. Suit to set aside the election of directors. D. Proceedings for dissolution of Muslim marriage. E. Claim by Swami to be carried out in palanquin on high road of town on occasion. F. Suit relating to costs property. Ans. The courts shall, subject to the provisions herein contained, have jurisdiction to try all suits of a civil nature excepting suits of which their cognizance is either expressly or impliedly barred. Explanation I. A suit in which the right to property or to an office is contested is a suit of a civil nature, notwithstanding that such right may depend entirely on the decision of question as to religious rites or ceremonies. Explanation 2. For the purpose of this section, it is immaterial whether or not any fees are attached to the office referred to in Explanation I or whether or not such office is attached to a particular place. So, in view of Section 9 of Code, A. Suit for dismissal from post of honorary secretary of an association is not suit of civil nature within the meaning of Section 9. B. Suit for exclusion of a member from a caste is a one cognizable by civil court because exclusion of someone from his caste affects his legal right. C. Suit to set aside the election of directors is suit of civil nature because in such suit, legal right of someone for being appointed as directors is challenged. D. Proceeding for dissolution of Muslim marriage is purely a suit of civil nature. Claim of any Swami to be carried out in palanquin is not a suit of civil nature, because it does not involve any legal right of Swami but claim is mark of honor. F. Suit for inspection of accounts of caste property is a civil nature, as every member of caste is entitled to inspect account books at all reasonable times on demand. Q. 10. Does the Code of Civil Procedure make any provision preventing courts of concurrent jurisdiction from trying at the same time to parallel suits in respect of same cause of action? If so, what? Discuss. Ans. Section 10 of the Code deals with the stay of civil suits. It reads, no court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially in issue in a previously instituted suit between the same parties, or between parties under whom they or any of them claim litigating under the same title where such suit is pending in the same or any other court in India having jurisdiction to grant the relief claimed, or in any court beyond the limits of India established or constituted by the central government and having like jurisdiction, or before the Supreme Court. The object of the rule contained in Section 10 is to prevent the courts of concurrent jurisdiction from simultaneously entertaining and adjudicating upon to parallel litigations in respect of the same cause of action, the same subject matter, and the same relief. The policy of the law is to confine the plaintiff to one litigation, thus obviating the possibility of two contradictory verdicts by one and the same court in respect of the same relief. In Shetty v. Giridhar, AIR 1982 SC 83, it was held. For the application of this section, the following conditions must be satisfied. 1. There must be two suits, one previously instituted and the other subsequently instituted. 2. The matter in issue in the subsequent suit must be directly and substantially in issue in the previous suit. 3. Both the suits must be between the same parties or their representatives. 4. The previously instituted suit must be pending in the same court in which the subsequent suit is brought or in any other court in India or in any court beyond the limits of India established or continued by the central government or before the Supreme Court. 5. The court in which the previous suit is instituted must have jurisdiction to grant the relief claimed in the subsequent suit. 6. Such parties must be litigating under the same title in both the suits. Q. 11. A suit for partition of premises has filled by one of the heirs. Subsequently, another suit for eviction of tenant from their premises was filled by another heir. Can the subsequent suit be stayed in view of Section 10 of CPC? Ans. Section 10 of Civil Procedure Code deals with doctrine of sub judice. Section 10 says, no court shall proceed with the trial of any suit in which the matter in issue is also directly the substantially in issue in a previously instituted suit between the same parties, or between parties under whom they or any of them claim litigating under the same title where such suit is pending in the same or any other court in India having jurisdiction to grant the relief claimed, or in any court beyond the limits of India established or continued by the central government and having like jurisdiction, or before the Supreme Court. So what is important to invoke Section 10 is that subsequently filed suit should be for same cause of action and between same parties, and matter in issue in previous and subsequent suits must be directly and substantially the same. Where the cause of action and reliefs are different, it cannot be said that the matter in issue between the two suits is directly and substantially the same. Identity of one or two issues is not enough. What has to be seen is whether the field of controversy is the same and whether the final decision in the previous suit is such as would operate as res judicata in the subsequent suit. Where one of the heirs to the premises filed a suit for declaration of his share, and of the other heirs pleaded as defendants and for partition, and the subsequent suit was filed by another heirs for eviction of the tenant from those premises, and the plaintiff in the first suit also being heirs was pleaded as pro forma defendant, the controversy in the two suits cannot be said to be the same, as the controversy in the first suit relates to the share of the parties in the premises and the subsequent suit for eviction has nothing to do with the same. Therefore, the subsequent eviction suit need not be stayed under Section 10 CPC. Q12B residing in Calcutta has an agent at Calicut employed to sell his goods there. Assumes B in Calicut claiming a balance due upon an account in respect of dealing between him and B. During the pendency of the suit in Calicut, court competent to grant relief B institute a suit against A in Calcutta for an account and damages caused by A's alleged negligence. Can the Calcutta court proceed with trial of B's suit? Ans. Rule of res sub judice as embodied in Section 10 of CPC says no court shall proceed with trial of any suit in which the matter in issue is also directly and substantially in issue in previously instituted case between same parties or parties under whom they or any of them claim, litigating under same title, pending in the same court or any other court competent to grant relief claimed or any court beyond limits of India established or constituted by central government or before Supreme Court. So when a suit between same parties is already pending in a competent court and question involved therein is again directly and substantially raised in other suit instituted subsequently, then such subsequent suit will not be allowed to proceed in view of provision of Section 10 CPC. In case in hand when matter between A and B is already pending in Calicut court, which is competent court, then a like matter in suit subsequently filed by B at Calcutta shall not be proceed. Q13. What is the scope and object of doctrine of res judicata? Discuss the conditions necessary for its application in legal proceedings. Ans. Section 11 of Civil Procedure Code embodies the doctrine of res judicata, which is based on the need of giving finality to judicial decisions. It is a rule of conclusiveness of judgment as to the points decided either of facts or of law or fact and law in every subsequent suit between the same parties. It simply enacts that once a matter is finally decided by a competent court, no party can be permitted to reopen it in subsequent litigation. The doctrine of res judicata is based on three maxims. 1. Nemo det lis vexari pro uno et edin causa. No man should be vexed twice for same cause. 2. Interest republica ut sit finis litium. It is in the interest of the state that there should be an end to a litigation. 3. Res judicata pro veritate occipitur. A judicial decision must be accepted as correct. Section 11 CPC provide as under. No court shall shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties or between parties under whom they or any of them claim, litigating under the same title, in a court competent to try such subsequent suit or the suit in which such issue has been subsequently raised and has been heard and finally decided by such court. In Darya v. State of UP, AR 1961 SC 1457 Supreme Court observed, the binding character of judgment pronounced by court of competent jurisdiction is itself an essential part of rule of law, and rule of law obviously is the basis of administration of justice on which the Constitution lays so much emphasis. In Sheldon Singh v. Daryao Kumar AIR 1966 SC 1332 it was held that it is not every matter decided in a former suit that will operate as res judicata in a subsequent suit. To constitute a matter res judicata under Section 11 the following conditions must be satisfied. A. The matter directly and substantially in issue in the subsequent suit or issue must be the same matter which was directly and substantially in issue either actually or constructively in the former suit. B. The former suit must have been a suit between the same parties or between parties under whom they or any of them claim. C. Such parties must have been litigating under the same title in the former suit. D. The court which decided the former suit must be a court competent to try the subsequent suit or the suit in which such issue is subsequently raised. Explanations 2 and 7 are to be read with this condition. D. The matter directly and substantially in issue in the subsequent suit must have been heard and finally decided by the court in former suit. Q. 14. A. Discuss the doctrine of constructive res judicata. B. A sues B to recover certain property belonging to the estate of C, alleging that his A's father had been adopted by C.'s brother D, to whom the property descended on C.'s death. The suit is dismissed on the ground that the adoption is not proved. A then sues B to recover the same property claiming it as C.'s bandhu. Is the suit barred as res judicata? C. A. Alleging that he is the adopted son of X sues B to recover certain property granted to him by X under a deed and forming part of the estate of X. The court finds that A is not the adopted son of X, but that he is entitled to the property under the deed and a decree is passed in favor of A. Will the finding that A is not the adopted son of X operate as res judicata in a subsequent suit between A and B in which the question of adoption is again put in issue? Ans. A. Rule of res judicata as contemplated by Section 11 applies only when a matter directly and substantially in issue in a suit has also been directly and substantially in issue in a former suit between same parties, and such matter has been heard and finally decided in that former suit by competent court. A matter directly and substantially in issue may be so either actually or constructively. A matter is actually in issue when it is alleged by one party and denied or admitted by the other. Explanation 3. It is constructively in issue when it might and ought to have been made a ground of attack or defense in the former suit. Explanation 4 to Section 11 by a deeming provision lays down that any matter which might and ought to have been made a ground of defense or attack in the former suit, but which has not been made a ground of attack or defense, shall be deemed to have been a matter directly and substantially in issue in such suit. In State of UP v. Nawab Hussain, AIR 1977 SC 1681A, a sub-inspector of police, was dismissed from service by DIG. He challenged the order of dismissal by filing a writ petition in the High Court on the ground that he was not afforded reasonable opportunity of being heard before passing the order. The contention was, however, negatived and the petition was dismissed. He then filed a suit and raised an additional ground that since he was appointed by IGP, DIG had no power to dismiss him. The state contended that the suit was barred by constructive res judicata. The trial court, the first appellate court as well as the High Court held that the suit was not barred by res judicata. Allowing the appeal filed by the state, the Supreme Court held that the suit was barred by constructive res judicata as the plea was within the knowledge of the plaintiff and could well have been taken in earlier writ petition. It was observed by Supreme Court. When any matter which might and ought to have been made a ground of defense or attack in a former proceeding but was not so made, then such a matter in the eye of law, to avoid multiplicity of litigation and to bring about finality in it, is deemed to have been constructively in issue and, therefore, is taken as decided. Ans. B. Rule of constructive res judicata as embodied in Explanation 4 to Section 11 CPC is an artificial form of res judicata and provides that if a plea should have been taken by a party in a proceeding between him and his opponent, but was not actually taken in that former suit, he should not be permitted to take that plea against the same party in a subsequent proceeding with reference to same subject matter. Explanation 4 to Section 11 CPC provides any matter which might or ought to have been made a ground of defense or attack in the former suit, but which has not been made ground of attack or defense shall be deemed to have been matter directly and substantially in issue in such suit. Coming now to case in hand, when a filed earlier suit against B, it was open to A to take the plea of CS Bandhu to recover property, but A did not take that plea and only made his claim on the basis of alleged adoption of his father by D, who was CS' brother. A's earlier suit was dismissed and now A's second suit is barred by constructive res judicata. Ans. C. One of the requirements for application of rule of res judicata as embodied in Section 11 CPC is that judgment of court must be on a matter which was directly and substantially in issue between parties. When a court of competent jurisdiction hears and finally decides any matter which was directly and substantially in issue between parties, it will only operate res judicata in any subsequent suit between same parties if that matter is again directly and substantially in issue in such subsequent suit. The words directly and substantially in issue have been used in Section 11 in contradiction to words collaterally and incidentally in issue. Decisions on the matters collateral and incidental to main issues in the case will not operate as res judicata. A collateral or incidental issue means an issue which is ancillary to direct and substantive issue. Recently, Supreme Court in Madhvi Amma Bhavani Amma and others v. Kunjikutti Pillai Meenakshi Pillai and others, AIR 2000 SC 2301 observed. In order to apply the general principle of res judicata, court must find whether an issue in subsequent suit was directly and substantially in issue in earlier suit or proceeding, was it between the same parties, and was it decided by such court. Thus there should be an issue raised and decided, not merely any finding on any incidental question for reaching such decision. So if no such issue is raised, and if on any other issue if incidentally any finding is recorded, it would not come within the periphery of principle of res judicata. Moreover, a finding on an issue cannot be said to be necessary to the decision of a suit unless the decision was based upon that finding. In the case in hand, the finding that A is not the adopted son of X will not operate as res judicata in a subsequent suit between A and B in which the question of adoption is again put in issue, for the decree being in favor of A could not have appealed from that finding. The court having found that A was entitled to the property under the deed, the finding on the question of adoption was not necessary to the determination of the suit. The decree, far from being based on the finding as to adoption, was made in spite of it. Q15 explain the significance of the matter collaterally or incidentally in issue determining the principles of res judicata. Ans. Matter collaterally or incidentally in issue. The expression collaterally or incidentally in issue implies that there is another matter, which is directly and substantially in issue, and the matter collaterally and incidentally is only incidental to the direct and substantial issue. Collateral and incidental issues are the auxiliary issues, while direct and substantial issues are principal issues. A collateral or incidental issue is an issue in respect of which no relief is claimed but which is put in issue to enable the court to adjudicate upon the matter which is directly and substantially is issue. It is only those matters which are directly and substantially in issue that constitute res judicata, and not the matters which are in issue only collaterally or incidentally. The matter could be directly and substantially in issue if the issue was decided and judgment was, in fact, based upon that decision. Otherwise, it would be a matter collaterally or incidentally in issue. An illustration will further elucidate the point. A sues B for rent for the year 1975 and B claims abatement of rent on the ground that the area is greater than shown in the lease. The finding as to the excess area is not res judicata, for this was not the matter directly and substantially in issue but only anciently to the direct and substantial issue, viz., whether the area is equal to that shown in the lease or less. Q16 res judicata is sometimes treated as part of the doctrine of estoppel, but the two are essentially different. Explain and point out the difference between the two. Ans. The doctrine of res judicata is often treated as a branch of law of estoppel. Res judicata is really estoppel by verdict or estoppel by judgment, record. The rule of constructive res judicata is nothing else but a rule of estoppel. Even then, the doctrine of res judicata differs in essential particulars from the doctrine of estoppel. 1. The rule of res judicata is based on public policy, was that there should be an end to litigation. Estoppel, on the other hand, proceeds upon the doctrine of equity, that he who, by his conduct, has induced another to alter his position to his disadvantage, cannot turn round and take advantage of such alteration of the other's position. 2. Res judicata ousts the jurisdiction of the court to try the case and precludes an inquiry in limine. At the threshold, estoppel is only a rule of evidence and shuts the mouth of a party. 3. Res judicata results from a decision of the court, whereas estoppel flows from the acts of parties. 4. The rule of res judicata presumes conclusively the truth of the decision in the former suit, while the rule of estoppel prevents a party from denying what he has once called the truth. 5. Res judicata prohibits a man averring the same thing twice in successive litigations, while estoppel prevents him from saying one thing at one time and the opposite at another. Q17. A. 9 Akali 6 sue for removal of mahant of a religious institution. The suit is dismissed on the ground that the institution is Hindu Dera and not a Sikh Gurudwara. Subsequently and after the passing of Sikh Gurudwara Act 1925, 64 Sikhs sue for declaration that institution is Sikh Gurudwara. Is the suit is barred by res judicata? B. A Hindu dies leaving widow and brother B. The widow sues B for recovery of certain property alleging that it was a self-acquired property of her husband and that a will alleged to have been executed by her husband and relied upon by B was a forgery. B alleges that the property was joint family property and that on the death of A he became entitled thereto by right of survivorship, but he does not claim any title to the property under the will. The court finds that the property was self-acquired property of A and decrees the widow's claim. Subsequently, B sues the widow to recover same property from her, now claiming the same as devisee under A's will. Is the suit barred by res judicata? Ans. A. For the application of rule of res judicata, as enshrined under Section 11 of CPC, one of the conditions is that former suit must be between the same parties or parties under whom they claim litigating under same title as in subsequent suit. However, Explanation 6 of Section 11 provides, where persons litigate bona fide in respect of public right or a private right claimed in common for themselves and others, all persons interested in such right shall, for the purpose this section, be deemed to claim under the person so litigating. So Explanation 6 to Section 11 deals with representative suits, i.e. suits instituted by or against a person to his representative as distinguished from individual capacity. Thus, where a representative suit is brought under Section 90 to CPC and decree is passed in such suit, law assumes that all persons who have same interest as plaintiff in representative suit were represented by said plaintiffs and therefore are constructively barred by res judicata from reagitating the matter directly and substantially in issue in former suit. In Forward Construction Kovi, Prabhat Mandal, AIR 1986 SC 391, it was held that there must be a right claimed by one or more persons in common for themselves and others not expressly named in the suit. 2. Parties not expressly named in suit must be instructed in such right. 3. Litigation must have been conducted bona fide and on behalf of all parties interested and 4. If suit is under Order 1 Rule 8, all conditions of such provision must have been strictly complied with. It is only then that decision may operate as res judicata. But where a party claims right for himself alone, which happens to be common to him and other, then it cannot be said that he was litigating on behalf of other, and Explanation 6 of Section 11 CPC does not apply. In the case in hand, earlier suit was filed by 9 Akali Sikhs for removal of Mahant of religious institution. These Akali Sikhs were claiming in suit not as representatives for all Sikhs, but they were having their individual claim in that suit. Therefore, decision in the former suit cannot operate as res judicata in subsequent suit which was filed by 64 Sikhs after passing of Sikh Gurudwara Act, 1925. B. Rule of res judicata applies in respect of only those matters which were directly and substantially in issue in former suit and which were heard and finally decided in that suit by court, and are directly and substantially in issue in subsequent suit between same parties. Explanation 3 to Section 11 says all those matters which have been alleged by one party and either denied or admitted by the other, expressly or impliedly, are deemed to be directly and substantially in issue within the meaning of Section 11 CPC. Explanation 4 of Section 11 CPC provides any matter which might or ought to have been made ground of defense or attack in such former suit, but which has not been made ground of attack or defense, shall be deemed to have been matter directly and substantially in issue in such suit. So explanation 4 to Section 11 provides for rule of constructive res judicata and provide if a plea could have been taken by a party in proceedings between him and his opponent, he could not be permitted to take that plea against the same party in a subsequent suit with reference to the same subject matter. In State of UP v. Nawab Hussain, AIR 1977 SC 1681 Supreme Court observed, when any matter which might and ought to have been made a ground of defense or attack in a former proceeding but was not so made, then such a matter in the eye of law, to avoid multiplicity of litigation and to bring about finality in it, is deemed to have been constructively in issue and therefore is taken as decided. Coming now to case in hand, when widow of a files suit against B for recovery of property on the ground of will allegedly executed by A, and on the ground that suit property was A's self-acquired property, B contested that suit only on the ground that suit property was joint property and not A's self-acquired property. B in that suit could have taken the defense for which he filed second suit in reference to same property and against same party, i.e. widow of A. Therefore, bar of constructive res judicata will apply in respect of suit filed by B for recovery of property on the ground of A's will. Q18. A. What is premature discovery? B. What is the penalty for non-compliance by a party with the order of the court for discovery of document? Ans. A. Premature discovery. Rule 20. The court is empowered to postpone a premature discovery or inspection. A discovery is premature when the right to discovery depends upon the determination of any issue or question in dispute, or for any other reason it is desirable that any issue or question in dispute in suit should be determined before deciding upon the right to the discovery. In such a case, the court may order that issue or question to be determined first and reserve the question as to the discovery thereafter. The rule, however, does not apply where discovery is necessary for the determination of such issue or question. B. Non-compliance with order. Rule 21. Where any party fails to comply with any order to answer interrogatories or for discovery or production of documents, if such party happens to be a plaintiff, his suit may be dismissed for want of prosecution. And if he happens to be a defendant, his defense will be struck off and will be placed in the same position as if he had not defendant. Such order, however, can be passed only after giving notice and a reasonable opportunity of being heard to the plaintiff or the defendant, as the case may be. If the suit of the plaintiff is dismissed on this ground, he cannot file a fresh suit on the same cause of action. In Barber Sewing Machine Co. Triloki Nath, AIR 1978 SC 1436, the court ordered the defendant to produce certain documents. The defendant did not comply with that order and his defense was, therefore, struck off. At the trial, he was not allowed to cross-examine the witnesses of the plaintiff. The defendant challenged that action. Setting aside the decision, the Supreme Court held that the stringent provisions of Order 11, Rule 21 should not be lightly invoked and must be applied only in extreme cases as a last resort. Q19 describe the procedure you will adopt in the case of discovery and inspection of documents in possession of the opposite party. Ans. Procedure in case of discovery and inspection of documents. Rule 12 of Order 11 provides that any party may, without filling any affidavit, apply to the court for an order directing any other party to any suit to make discovery on oath of the documents which are in his possession or power, relating to any matter in question therein. An application will, therefore, have to be made for discovery of documents in possession of the opposite party in terms of Rule 12, Order 11, CPC. The general rules as to discovery of documents may be summarized as under. 1. Any party to a suit may apply to the court for an order directing any other party to make discovery on oath of the documents which are or have been in possession or power, relating to any matter in question in the suit. 2. The court may either refuse or adjourn such application if satisfied that such discovery is not necessary or not necessary at that stage of the suit, or make such order as it thinks fit. 3. The court may exercise this power at any stage, either of its own motion or on an application of any party, and subject to such conditions and limitations as may be prescribed by it. 4. Generally, no order of discovery, inspection or production of documents will be passed by the court on the application of the plaintiff until the written statement is filed by the defendant or the time to file it has expired. 5. Discovery cannot be ordered by the court if it is of the opinion that it is not necessary either for the fair disposal of the suit or for saving costs. 6. A party against whom an order for discovery of documents has been made by the court is, as a general rule, bound to produce all the documents in his possession or power. However, if such party considers that he is entitled to legal protection in respect of a particular document which he has been ordered to produce by the court, he is at liberty to take such objection. 7. When such privilege is claimed for any document, the court will inspect such document for the purpose of deciding the validity of the claim of privilege, unless the document relates to matters of stage. Q20. What do you understand by foreign judgment? In what manner may a decree of foreign court be executed in India? Ans. Section 2, 6, CPC says, foreign judgment means judgment of foreign court. Foreign court means a court situated outside India and not established or continued by the authority of central government. Binding nature of foreign judgment, Section 13. Section 13 provides foreign judgment shall be conclusive as to any matter thereby directly adjudicated upon between the same parties or between parties under whom they or any of them claim litigating under the same title except 1. Where it has not been pronounced by court of competent jurisdiction. 2. Where it has not been given on merits of case. 3. Where it appears on the face of proceedings to be founded on incorrect view of international law or refusal of recognized principle of law in India. 4. Where the proceedings in which judgment was obtained are opposed to natural justice. 5. Where it has been obtained by fraud. 6. Where it sustains a claim founded on breach of any law in force in India. A combined reading of sections 43 to 44 shows that the Indian courts have power to execute the decrees passed by 1. Indian courts to which the provisions of the code do not apply. 2. The courts situate outside India which are established by the authority of the central government. 3. Revenue courts in India to which the provisions of the code do not apply, and 4. Superior courts of any reciprocating territory. In Sheikh Ali v. Sheikh Mohd. AIR 1967 Madras 45, A. It was held. The jurisdiction of district court in this country to execute foreign judgment arises from and is exercisable by the filing of a certified copy of foreign decree or judgment. It is only thereafter and never until then the procedural laws as to LEX4E will be attracted to execution. The Limitation Act can apply possibly to such execution only after filing a certified copy of the foreign decree or judgment as required by Section 44A(1) of Civil Procedure Code. In MS International Woolen Mills v. MS Standard Wools, UK, AIA 2001 SC 2134, it was observed Section 44-A CPC says where a certified copy of decree of any superior court of any reciprocating territory has been filed in district court along with certificate from such superior court stating the extent if any to which the decree had been satisfied or adjudicated, decree may be executed in India as if it had been passed in India. Court observed regarding Section 13(b) CPC that it cannot be said that expression foreign judgment on merit implies that it must have been passed after contest and after evidence had been let in from both the side. An ex parte foreign decree and judgment in favor of plaintiff may deem to be judgment given on merit if some evidence is adduced on behalf of plaintiff and judgment is based on consideration of that evidence. Q. 21. How a suit is to be instituted? What are the rules regarding institution of suits? Ans. A suit is to be instituted by presentation of a plaint or in any prescribed manner. Sections 15 to 20 of Code of Civil Procedure regulate the forum for the institution of suits. Section 15 of Code says, every suit shall be instituted in the court of the lowest grade competent to try it. So Section 15 refers to the pecuniary jurisdiction of the court. Underlying object of Section 15 is to see that court of higher grade may not be overburdened with suits and to ensure that justice may be provided at the doorstep of litigants. Suits to be instituted where subject matter situates. Section 16 of the Civil Procedure Code provides that, subject to the pecuniary or other limitations prescribed by any law, suits regarding immovable property are to be instituted in court within whose local jurisdiction the property is situate. However, it has also been provided in its proviso that a suit to obtain relief respecting or compensation for wrong to immovable property held by or on behalf of the defendant may, where the relief sought can be entirely obtained through his personal obedience, be instituted either in the court within the local limits of whose jurisdiction the property is situate, or in the court within the local limits of whose jurisdiction the defendant actually resides or carries on business or personally works for gain. Suits for immovable property situate within jurisdiction of different courts. Section 17 of the Civil Procedure Code provides that where a suit is to obtain relief respecting or compensation for wrong to immovable property situate within the jurisdiction of different courts, the suit may be instituted in any court within the local limits of whose jurisdiction any portion of the property is situate, provides that in respect of the value of the subject matter of the suit, the entire claim is cognizable by such court. Place of institution of suit where local limits of jurisdiction of courts are uncertain. Section 18 of the Code of Civil Procedure provides that where it is alleged to be uncertain within the local limits of jurisdiction of which of two or more courts any immovable property is situate, any one of those courts, if satisfied that there is ground for the alleged uncertainty, record a statement to that effect, and thereupon proceed to entertain and dispose of any suit relating to that property, and its decree in the suit shall have the same effect as if the property was situate within. the local limits of its jurisdiction, provided that the suit is one with respect to which the court is competent as regards the nature and value of the suit to exercise jurisdiction. Subsection 2 of Section 18 CPC further provides that where a statement has not been recorded under subsection 1, and an objection is taken before an appellate or revisional court that a decree or order in a suit relating to such property was made by a court not having jurisdiction where the property is situate, the appellate or revisional court shall not allow the objection unless in its opinion there was, at the time of the institution of the suit, no reasonable ground for uncertainty as to the court having jurisdiction with respect thereto, and there has been a consequent failure of justice. Suits for compensation for wrongs to person or movables. Section 19 of the Code of Civil Procedure provides that where a suit is for compensation for wrong done to the person or to movable property, if the wrong was done within the local limits of the jurisdiction of one court and the defendant resides, or carries on business, or personally works for gain, within the local limits of the jurisdiction of another court, the suit may be instituted at the option of the plaintiff in either of the said courts. Other suits to be instituted where defendant resides or cause of action arises. Section 20 of the Code of Civil Procedure provides that subject to the aforesaid rules, every other suit shall be instituted in a court within the local limits of jurisdiction. I. Where the cause of action, wholly or partly, arises, or 2. Where the defendant resides, or carries on business or personally works for gain, or 3. Where there are two or more defendants, any of them resides or carries on business or personally works for gain, provided that in such case, a. Either the leave of the court is obtained, or b. The defendants who do not reside or carry on business or personally work for gain at that place acquiesce, agree to, in such institution. Explanation: a corporation shall be deemed to carry on business at its sole or principal office in India, in respect of any cause of action arising at any place where it has also a subordinate office, at such place. Q20 to plaintiff: a resident of Faridabad has filed a suit in Delhi courts against the defendant, a resident of Delhi, for declaration that he has half share in the house situated in Kanpur and in the sum of 50,000 rupees lying deposited in a bank in Delhi, and that defendant has wrongfully got the house registered in his own name and is also not admitting the claim of plaintiff in the amount. The defendant has contested the suit on the ground that Delhi courts have no jurisdiction to try the suit. How will you decide? Ans. Sections 15 to 20 of Civil Procedure Code regulate the forum for the institution of suits. Section 16 of CPC is relevant here, which provide: subject to pecuniary or other limitation prescribed by any law, suits a. for the recovery of immovable property, b. for partition of immovable property, c. for foreclosure, sale or redemption in case of mortgage of or charge upon immovable property, d. for the determination of any other right to or interest in immovable property, d. for compensation for wrong to immovable property, f. for recovery of immovable property actually under distraint or attachment, shall be instituted in the court within the local limits of whose jurisdiction the property is situated. Provided that suit to obtain relief respecting or compensation for wrong to immovable property held by or on behalf of defendant may, where the relief sought can be entirely obtained through his personal obedience, be instituted either in court within the local limits of whose jurisdiction the property is situate, or in the court within the local limits of whose jurisdiction the defendant actually and voluntarily resides or carries on business or personally works for gains. In the present case, plaintiff's claim is right or interest in immovable property, which is situated at Kanpur. Therefore, in view of Clause D of Section 16, Delhi courts has no territorial jurisdiction to decide the suit for such immovable property. Therefore, plaintiff's suit for his right to or interest in immovable property situated at Kanpur shall not be maintainable. Now question arises as to claim of plaintiff for 50,000 rupees lying deposited at Delhi Bank. Here Section 20 of CPC is relevant, which provide that suits not covered by any rules provided under Section 16 to 18 shall be filed. A. Where the cause of action wholly or partly arises. B. Where defendant resides or carries on business or personally works for gain, or C. Where there are two or more defendants, any of them resides or carries on business or personally works for gains, provided in such case either leave of court is obtained or the defendant who does not reside or carry on business or personally works for gains at that place acquiesce in such institution. Defendant in present case resides at Delhi and sum of 50,000 rupees, in respect of which cause of action arose, also lying deposited at Delhi Bank. Therefore, in view of provisions of Section 20 CPC, plaintiff's suit at least for 50,000 rupees is maintainable at Delhi courts. Q. 23. A. X, Y and Z are joint owners of a property situated at Jaipur. X lives in Bombay, Y lives in Delhi and Z lives in Jaipur. In which court or courts can the suit for partition be filed? Give reasons. B. A residing in Bombay publishes in Delhi statements defamatory of B. Where can be filed a suit for compensation against A? Ans. A. Section 16 of the Code of Civil Procedure provides that suits relating to immovable property are to be instituted where subject matter is situated. Its proviso also provides that if the relief sought can be entirely obtained through the personal obedience of the defendant, the suit may be instituted either in the court within the local limits of whose jurisdiction the defendant resides or carries on business or personally works for gain. That being so, suit for partition of property situated at Jaipur. Proviso to Section 16 CPC will not be attracted in present case. X, Y and Z are joint owners. X lives in Bombay, Y lives in Delhi and Z lives at Jaipur. Therefore, in case in hand, suit for partition of property can be filed at Jaipur, where suit property is situated. B. This problem is covered by Section 19 of CPC, which provides that suit for compensation for wrong to persons or movable property can be filed either where the wrong is committed or where defendant resides or carries on business or personally works for gain. In case in hand, A. Defendant was residing in Bombay, while defamatory statement was published in Delhi by A. So B can file suit again A either at Bombay where A resides or at Delhi where defamatory statement was published. Q. 24. A transport company has its head office at Chandigarh and branch offices at Chennai, Jaipur and Mumbai. A dispute cropped up between SAM and the company in respect of a transaction made through Chennai office. SAM files a suit in respect of this dispute against the company in a court at Jaipur. How the court will decide? Ans. Section 20 of the Code of Civil Procedure, so far as it is relevant for our purpose, reads as under, subject to the limitations aforesaid, every suit shall be instituted in a court within the local limits of whose jurisdiction A. The defendant or each of the defendants where there are more than one, at the time of the commencement of the suit, actually and voluntarily resides, or carries on business, or personally works for gain, or b. Any of the defendants, where there are more than one, at the time of the commencement of the suit, actually and voluntarily resides, or carries on business, or personally works for gain, provided that in such case either the leave of the court is given, or the defendants who do not reside, or carry on business, or personally work for gain, as aforesaid acquiesce in such institution. C. Or the cause of action, wholly or in part, arises. Explanation. A corporation shall be deemed to carry on business at its sole or principal office in India or, in respect of any cause of action arising at any place where it has also a subordinate office, at such place. So, if a suit is filed against a corporation on the ground of its carrying on business, then in view if explanation to Section 20, suit will lie where the corporation has its head office even if no part of cause of action arises there or branch office where cause of action has arose. In the case in hand, the suit against the company can be filed at Chandigarh where it has its head office, or at Chennai where the company has its branch office, and cause of action has arisen at Chennai. No suit can be entertained by a court at Jaipur or Mumbai, although the company has its branch offices at those places, because no part of the cause of action arose either at Jaipur or Mumbai. Q. 25 A resides at Shimla, B at Calcutta, and C at Delhi. A, B and C being together at Varanasi, B and C make a joint promissory note payable on demand and deliver it to A. A files suit for recovery at Varanasi, B and C object to jurisdiction of court at Varanasi to try the suit asserting that defendants B and C do not reside at Varanasi. How would you decide the objection? Ans. Section 20 of the Code of Civil Procedure provides as under. Subject to the limitations aforesaid, every suit shall be instituted in a court within the local limits of whose jurisdiction A. The defendant, or each of the defendants where there are more than one, at the time of the commencement of the suit, actually and voluntarily resides, or carries on business, or personally works for gain, or B. Any of the defendants, where there are more than one, at the time of the commencement of the suit, actually and voluntarily resides, or carries on business, or personally works for gain, provided that in such case either the leave of the court is given or the defendants who do not reside, or carry on business, or personally work for gain, as aforesaid, acquiesce in such institutions, or C. The cause of action, wholly or in part, arises. Under this section, the plaintiff has the option of suing at a place either where the cause of action or a part thereof has accrued, or in the forum of the defendant, i.e., where the defendant resides, or carries on business, or personally works for gain. In view of the provisions contained in Clause B of Section 20 of the Code, I can file the suit at Calcutta where B resides, or at Delhi where C resides, but in each of these cases either the non-resident defendant should acquiesce in such institution or the leave of the court should be obtained. If the non-resident defendant objects, the suit cannot proceed without the leave of the court. In the present case, the joint promissory note payable on demand was executed by B and C at Varanasi. In other words, the contract was made at Varanasi. It is a settled proposition of law that the making of the contract is a part of the cause of action, and, as such, a suit can be filed on the basis of the said pronote at Varanasi where the cause of action arose. Q. 26. Determine the place of suing in the following cases. I. A resident of Delhi, B. A resident of Bangalore and C. of Calcutta, meet at Kurukshetra. There, B and C borrowed 10,000 rupees from A and jointly executed a pronote and handed it over to A. All of them went back to their respective places, but the money was not returned. A wants to file a suit for recovery of his money. 2. Father of A and B had a bungalow at Gurgaon, one house at Rohtak and Delhi each and two big mango groves in the district of Hisar. After the death of the father, A took over the management of the entire property and began appropriating the income. B wants to sue for partition of the property. Ans. I. Section 20 of the Code of Civil Procedure provides as under. Subject to the limitations aforesaid, every suit shall be instituted in a court within the local limits of whose jurisdiction A. The defendant, or each of the defendants where there are more than one, at the time of the commencement of the suit, actually and voluntarily resides, or carries on business, or personally works for gain, or B. Any of the defendants, where there are more than one, at the time of the commencement of the suit, actually and voluntarily resides, or carries on business, or personally works for gain, provided that in such case either the leave of the court is given or the defendants who do not reside, or carry on business, or personally work for gain, as aforesaid, acquiesce in such institutions, or C. The cause of action, wholly or in part, is. In the present case, the joint promissory note payable on demand was executed by B and C at Kurukshetra. In other words, the contract was made at Kurukshetra. Therefore, A can file the suit on the basis of the said pronote at Kurukshetra where a part of the cause of action arose. In view of the provisions contained in Clause B of Section 20 of the Code, A can file the suit at Bangalore where B resides, or at Calcutta where C resides, but in each of these cases either of the non-resident defendants should acquiesce in such institution or the leave of the court should be obtained. If the non-resident defendant objects, the suit cannot proceed without the leave of the court. 2. Section 16 of the Code of Civil Procedure provides that subject to the pecuniary or other limitations prescribed by any law, a suit for partition of immovable property shall be instituted in the court within the local limits of whose jurisdiction the property is situate. Then Section 17 lays down that where a suit is to obtain relief respecting, or compensation for wrong to, immovable property situate within the jurisdiction of different courts, the suit may be instituted in any court within the local limits of whose jurisdiction any portion of the property is situate. This section is practically another proviso to Section 16(1) of the Code. Therefore, in the present case B can file a suit for partition of the said properties in any one of the courts at Gurgaon, Rohtak, Delhi or Hisar. Q. 27. When can an objection to jurisdiction be raised? Can an objection as to territorial or pecuniary jurisdiction of the court be raised by a party before the Court of Appeal or Revision? Ans. Section 21 of the Code of Civil Procedure deals with the question of objections to jurisdiction of court. It is important to point out here that objection as to territorial jurisdiction of a court does not stand at par with objection as to competency of court to try a case. Competency of a court to try a case goes to the very root of the jurisdiction, and where it is lacking it is incurable irregularity, vitiating the whole proceedings, whereas objection as to local jurisdiction of a court can be waived. Section 21 of Code is based on this principle. Objection as to territorial jurisdiction under Section 21. 1. No objection as to the place of suing will be allowed by an appellate or revisional court unless the following three conditions are satisfied. I. The objection was taken in the court of first instance. 2. It was taken at the earliest possible opportunity and in cases where issues are settled at or before settlement of issues, and 3. There has been a consequent failure of justice. Objection as to pecuniary jurisdiction subsection 2 of Section 21 of the Code of Civil Procedure provides that no objection as to the competence of a court with reference to the pecuniary limits of its jurisdiction shall be allowed by any appellate or revisional court unless such objection was taken in the court at first instance at the earliest possible opportunity and in all cases where issues are settled on or before such settlement, and unless there has been a consequent failure of justice. So Section 21, which confines its application only to objections as to territorial or pecuniary jurisdiction of a court and provides that defects as to place of suing under Section 15 to 20th may be waived if defendant allows the trial court to proceed to decide the matter without raising objection in this regard. In Kiran Singh v. Chaman Paswan, AIR 1954 SC 340, it was observed, when a case had been tried by a court on the merits and judgment rendered, it should not be liable to be reversed purely on technical grounds unless it had resulted in failure of justice, and the policy of the legislature has been to treat objections to both territorial and pecuniary as technical and not open to consideration by an appellate court unless there has been a prejudice on merits. Q28. What are the provisions relating to transfer of a civil suit? Ans. Sections 22 to 25 of the Code of Civil Procedure lay down the provisions relating to transfer of a suit. Section 22 of the Code of Civil Procedure provides that where a suit may be instituted in any one of two or more courts and is instituted in one of such courts, any defendant, after notices to the other parties, may at the earliest possible opportunity, and in all cases where issues are settled, at or before such settlement, apply to have the suit transferred to another court, and the court to which such application is made, after considering the objections of the other parties, if any, shall determine in which of the several courts having jurisdiction the suit shall proceed. Section 23 of the Code of Civil Procedure further lays down in which court such application lies. According to it, the position is as follows. I. Where the several courts having jurisdiction are subordinate to the same appellate court, an application under Section 22 shall be made to the appellate court. 2. Where such courts are subordinate to different appellate courts, but to the same High Court, the application shall be made to the said High Court. 3. Where such courts are subordinate to different High Courts, the application shall be made to the High Court within the local limits of whose jurisdiction the court in which the suit is brought is situate. Apart from the said provisions relating to transfer, Section 24 of the Code of Civil Procedure deals with the general powers of transfer and withdrawal. It provides that on the application of any of the parties, and after notice to the parties, and after hearing such of them as desires to be heard, or of its own motion without such notice, the High Court or the District Court may at any stage withdraw any suit, appeal or other proceedings before it for trial or disposal to any court subordinate to it and competent to try or dispose of the same, or withdraw any suit, appeal or other proceeding pending in any court subordinate to it. In case of withdrawal, it can try or dispose of the same, or transfer the same for trial or disposal to any court subordinate to and competent to try or dispose of the same, or retransfer the same for trial or disposal to the court from which it was withdrawn. By adding subsection 3 to Section 24 of the Code of Civil Procedure, by the Amendment Act of 1976, it has further been clarified that courts of additional and assistant judges shall be deemed to be subordinate to the district judge court, and proceeding includes a proceeding for the execution of a decree or order. It has further been provided by subsection 5, which too has been added by the Amendment Act of 1976, that a suit proceeding may be transferred under this section from a court which has no jurisdiction to try it. Section 25 of Code provide regarding power of Supreme Court to transfer suits, etc. Section 25(1) says that on application of a party, and after notice to the parties, and after hearing such of them as desire to be heard, the Supreme Court may at any stage, if satisfied that an order under this section is expedient for the ends of justice, direct that any suit, appeal or other proceeding be transferred from a high court or other civil court in one state to a high court or other civil court in any other state. Q29. What do you understand by an interpleader suit? State the relevant provisions contained in the Code of Civil Procedure Code with regard to such a suit. Ans. A. Meaning an interpleader suit is a suit in which the real dispute is not between the plaintiff and the defendant but between the defendants only, and the plaintiff is not really interested in the subject matter of the suit. In other words, in an interpleader suit, the defendants interplead, i.e., plead against each other instead of pleading against the plaintiff as in an ordinary suit. Section 88 enacts that where two or more persons claim adversely to one another the same debt, sum of money or other property, movable or immovable, from another person who does not claim any interest in it except the charges or costs, and is ready to pay or deliver it to the rightful claimant, such person may file an interpleader suit. B. Conditions. The following conditions must be satisfied before an interpleader suit can be instituted. 1. There must be some debt, sum of money or other property movable or immovable in dispute. 2. Two or more persons must be claiming it adversely to one another. 3. The person from whom such debt, money or property is claimed must not be claiming any interest therein other than the charges and costs, and he must be ready to pay or deliver it to the rightful claimant. And 4. There must be no suit pending in which the rights of the rival claimants can be property decided. C. Procedure Order 35 lays down the procedure relating to an interpleader suit. In every interpleader suit, the plaintiff, in addition to other statements necessary for plaintiffs, state I. that the plaintiff claims no interest in the subject matter in dispute other than the charges or costs. 2. The claims made by the defendants severally. And 3. There is no collusion between the plaintiff and any of the defendants. The court may order the plaintiff to place the thing claimed in the custody of the court and provide his costs by giving him a charge on the thing claimed. Where any of the defendants in an interpleader suit files a suit against the plaintiff in another court in respect of the subject matter of the suit, that court shall stay the proceedings. At the first hearing, the court may declare that the plaintiff is discharged from all liability, award him his costs, and dismiss him from the suit, or if it thinks that justice or convenience so requires, retain all parties until the final disposal of the suit. Where the admission of the parties or other evidence enables the court to do so, it may adjudicate the title to the thing claimed. Q30. What do you understand by non-joinder and misjoinder of parties and misjoinder of causes of action? Ans. The question of joinder of parties may arise either as regards the plaintiffs or as regards the defendants. Order 1 deals with the subject of parties to suit and inter alia, amongst other things, with the joinder, misjoinder and non-joinder of parties, and to some extent with the joinder of cause of action. Joinder of plaintiffs. Rule 1. All persons may be joined in one suit as plaintiffs where a. Any right to relief in respect of, or arising out of, the same act, or transaction, or series of acts, or transactions, is alleged to exist in such persons whether jointly, severally, or in the alternative, and b. If such persons brought separate suits, any common question of law or fact would arise. A enters into an agreement jointly with B and C to sell 100 tins of oil. A thereafter refuses to deliver the goods. Here both B and C have each of them a right to recover damages from A. The said right arises out of the same transaction, namely, the breach of agreement, and common questions of law and fact would also arise. B and C, therefore, may file a suit jointly as plaintiffs against A for damages. Separate trials. Rule 2. Where it appears to the court that any joinder of plaintiff may embarrass or delay the trial of the suit, the court may put the plaintiffs to their election or order separate trials or make such other order as may be expedient. Joinder of defendants. Rule 3. All persons may be joined in one suit as defendants where a. Any right to relief in respect of, or arising out of, the same act or transaction or series of acts or transactions is alleged to exist against such persons, whether jointly, severally, or in the alternative, and b. If separate suits were brought against such persons, any common question of law or fact would arise. Before going into non-joinder or misjoinder of parties, it is necessary to understand the meaning of necessary party and proper party. A necessary party is one whose presence is indispensable for proceeding with the suit and for final decision thereof. On the other hand, proper party is one in whose absence an effective order can be passed, but whose presence is necessary for complete and final decision of suit. Misjoinder and non-joinder of parties where a person who is necessary or proper party to a suit has not been joined as a party to suit, it is a case of non-joinder. On the other hand, if two or more persons are joined as plaintiffs or defendants in one suit in contravention of Order 1 Rule 1 and 3 and they are neither necessary nor proper party, it is a case of misjoinder of parties. Order 1 Rule 9 says no suit shall be defeated by reason of the misjoinder or non-joinder of parties, and the court may in every suit deal with the matter in controversy so far as regards the rights and interests of the parties actually before it, provided that nothing in this rule shall apply to non-joinder of a necessary party. Misjoinder of causes of action. Order to Rule 3 of the Code of Civil Procedure provides that save as otherwise provided, a plaintiff may unite in the same suit several causes of action against the same defendant, or the same defendants jointly, and any plaintiffs having cause of action in which they are jointly interested against the same defendant or the same defendants jointly may unite such causes of action in the same suit. Therefore, if the plaintiffs are not jointly interested against the same defendant or defendants jointly, then there is a misjoinder of causes of action. It has further been provided in Order to Rule 7 CPC that all objections regarding misjoinder of causes of action shall be taken at the first hearing of the suit, i.e., at the earliest opportunity at or before settlement of issue, unless the ground of objection has subsequently arisen, and any such objection not so taken shall be deemed to have been waived. Same is the position regarding the objections as to non-joinder or misjoinder of parties as provided in Order 1 Rule 13 CPC. Q. 31A owned some land which B was cultivating as a tenant. I had 4 sons C, D, E and F. After A's death the land was sold by C, D, E and G son of predeceased son F to H wide registered sale deed DT. 12th February 1968, H filed suit for recovery of possession against B. B contested the suit on the ground inter alia that there are other co-owners of that property, and since all co-owners have not joined in the filing of suit, the suit is bad for non-joinder of necessary parties. In the written statement he also gave the pedigree table of A but did not lead any evidence in this regard. The revenue record also did not show that there was any other legal heir of A except C, D, E and G at the time of sale. So H contended that he is sole owner and suit is not bad for non-joinder of other co-owners decide. Ans. There is essential distinction between necessary party and proper party. A necessary party is one whose presence is indispensable or against whom relief is sought and without whom no effective order can be passed. A property party is one in whose absence an effective order can be passed, but whose presence is necessary for complete and final decision on question involved in proceedings. Order 1 Rule 9 of CPC provide that no suit shall be defeated by reason of the misjoinder or non-joinder of parties, and court may in every suit deal with the matter in controversy so far as regards the rights and interests of parties actually before it, provided that nothing in this rule shall apply to non-joinder of necessary party. So general rule is that no suit can be decided without necessary parties to it. However, Rule 10 of Order 1 CPC provides for substitution or addition of parties to suit on either of two grounds, namely A. He ought to have been joined as plaintiff or defendant and is not so joined, or B. Without his presence, the question involved in the suit cannot be completely decided. So precisely speaking, no suit shall be dismissed for non-joinder or misjoinder of parties unless it is shown that any necessary party is there which is not joined and without whom matter cannot completely and adequately decided. In Lakshmi Shankar v. Yash Ram Vasta AR 1993 SC 1587 Supreme Court, after relying upon the judgment of Pal Singh v. Sundar Singh AIR 1989 SC 758, wherein it was held that when other co-owner did not object to eviction, one co-owner could maintain eviction petition in the absence of other co-owner. Similarly, in A. Vishwanath Pilis case AIR 1991 SC 1966, wherein it was held that co-owner could successfully file suit and recover the property against stranger, held that in the absence of necessary proof it cannot be held that suit is not maintainable on the ground of non-joinder of necessary party. Coming now to case in hand, only issue for determination is whether plea of defendant B in the suit that necessary parties have not been joined is sustainable. In his written statement, defendant B has produced pedigree table. However, to substantiate his plea, B has not led any evidence as to necessary party. A vague statement of B could not be considered sufficient for attraction of provisions of Order 1 Rule 9 CPC. On the other hand, revenue record shows that there were no other legal heirs of A except B, C, D and G at the time of sale of suit property to plaintiff H. Therefore, in the absence of any proof that there are other co-owner and unnecessary parties, the suit cannot be dismissed for non-joinder of necessary parties. Q32. What do you understand by representative suit? Ans. The general rule is that all persons interested in the suit should be joined as party to it so that matter involved in it may finally and completely be adjudicated upon, and fresh litigation over the same matter may be avoided. Rule 8 of Order 1 of CPC is an exception to above said general rule. It provides that when there are a number of persons commonly interested in a suit, one or more of them can, with the leave or upon the direction of court, sue or be sued on behalf of themselves and other. Plaintiff in representative suit need not to obtain previous consent of persons whom he represents. Definition: representative suit may be defined as suit filed by or against one or more persons on behalf of themselves and others having same interest in the suit. Order 1 Rule 8 CPC has been enacted in order to save time and expense to ensure that a single comprehensive trial of question in which numerous persons are interested and also to avoid harassment to parties by multiplicity of suits. However, Order 1 Rule 8 CPC contains only enabling provisions and does not compel anyone to represent many. Order 1 Rule 8 also does not vest a right of suit in a person, if he by himself has no right to sue. It is necessary to bring the case within the provisions of Order 1 Rule 8. All the members of a class should have common interest in a subject matter, and a common grievance, and relief should in its nature be beneficial to all. Conditions following rules must exist for application of Rule 8 Order 1 of CPC. A. The parties must be numerous. B. They must have same or common interest in suit. C. Permission must have been granted or direction must have been given by the court. D. Notice must have been issued to parties whom it proposed to represent in the suit. Q. 33. Can a person file a fresh suit in respect of same cause of action when he has in a former suit relinquished part of his claim? Ans. Order to Rule 2 of the Code of Civil Procedure provides that every suit shall include the whole of the claim which the plaintiff is entitled to make in respect of the cause of action, but a plaintiff may relinquish any portion of his claim in order to bring the suit within the jurisdiction of any court. It further provides that if a plaintiff omits to sue in respect of, or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. Thus, the plaintiff is not entitled to split his cause of action into parts and bring separate of any portion of his claim arising from the same cause of action, or relinquishes part of his claim. He will be precluded from filing a fresh suit in respect of the same cause of action or the portion so omitted or relinquished. Order to Rule 2 of the Code of Civil Procedure is based on the principle that the defendant should not be vexed twice for the same cause. It is directed against the two evils, that is, splitting up of claims and splitting of remedies. As regards the remedies available in respect of the same cause of action, Sub-Rule 3 of Rule 2 of Order 2 of the Code of Civil Procedure provides that a person entitled to more than one relief in respect of the cause of the action may sue for all and any of such reliefs, but if he omits, except with the leave of the court, to sue for all such reliefs, he shall not afterwards sue for any relief so omitted. The following conditions are essential for attracting the provisions of Order to Rule 2 of the Code of Civil Procedure. I. That the second suit is in respect of the same cause of action as that on which the previous suit was based. 2. That in respect of the cause of action, the plaintiff was entitled to more than one relief, and 3. That the plaintiff without the leave of the court omitted to sue for the relief for which the second suit has been filed. Q. 34. A plaintiff who is entitled to sue for possession and damages files suit for damages only. Suit is decreed. Can he file suit for recovery and damages? Ans. Order 2 of Civil Procedure Code deal with frame of suit. Order to Rule 1 says, as far as practicable all matters in dispute between parties be disposed of finally. Order to Rule 2 provides that every suit must include whole of the claim to which plaintiff is entitled in respect of a cause of action, and where plaintiff omits to sue or intentionally relinquish any portion of his claim, he shall not afterwards be allowed to sue in respect of portion of claim so omitted or relinquished. Underlying object of legislature to enact this provision is thus so far as possible all the matters in dispute between parties in respect of same cause of action may be disposed of in the same suit so as to prevent further litigation. In Gurubaksh Singh v. Bura Lal AR 1964 SC 1810 it was held, to make the rule applicable, following conditions must be fulfilled. I. Second suit must be in respect of same cause of action as that on which a previous suit was based. 2. In respect of that cause of action, plaintiff was entitled to more than one relief. 3. Being so entitled, plaintiff without leave of the court omitted to sue for relief, for which now second suit has been filed. That being the legal position, in problem in hand Order 2, Rule 2 is not applicable because suit for mesne profit, damage for wrongful possession, arise subsequent to when suit for possession is decreed. Suit for possession and suit for damages for wrongful possession, mesne profits, are two distinct suit and have separate cause of action. Therefore, plaintiff after having suit for possession decreed can file suit for damages. Q. 35. A. Whether the court has power to order separate trials in respect of a suit in which several causes of action have been joined. B. Whether the court can order consolidation of pending suits. A suit is filed by a tenant for declaring him as a monthly tenant of the defendant landlord, and subsequently another suit is filed by landlord for recovery of possession of the same property from the tenant. Whether both these suits can be consolidated. Ans. A. Power of court to order separate trials. Order to Rule 6 of the Code of Civil Procedure provides that where it appears to the court that joinder of action in one suit may embarrass or delay the trial, or is otherwise inconvenient, the court may order separate trials or make such other order as may be expedient in the interest of justice. The object of Rule 6 is to prevent embarrassment or delay in the trial of suit, and it gives power to the court to order separate trials of causes of action whose joinder may cause embarrassment, but the defendant cannot claim the separation of the trials as of right. The said rule applies when it is open to the plaintiff to combine several causes of action in one suit, and it does not apply to a cause of misjoinder of causes of action. B. Yes. The court can order consolidation of pending suits in appropriate cases. It has been held in several cases that the courts have inherent jurisdiction to order consolidation of suits. The court should dispose of consolidated suits or appeals by one judgment. The consolidation is to be done keeping in view the convenience of all the parties concerned. Where a suit is filed by a tenant for declaring him as a monthly tenant of the defendant landlord and subsequently another suit is filed by landlord for recovery of possession of the same property from the tenant, both the suits can be consolidated, as held by the Hobbieli High Court of Calcutta in Humayun Properties Limited b. Narayan Das Arora, AIR 1983, NOC 189 Calcutta. Q. 36 State Rules relating to service of summons. ANS. Summons is a document issued from the office of a court of justice calling upon the person to whom it is directed to attend before a judge or officer of the court on the day mentioned therein. Wide Amendment Act, No. 22 of 2000 to Rule 1 to Order V has been amended. Sub-Rule 1. To Rule 1 says when a suit has been duly instituted, a summons may be issued to defendant to appear and answer the claim and to file the written statement of his defense, if any, within 30 days from the date of service of summons on that defendant. Provided that no such summons shall be issued when a defendant has appeared at the presentation of plaint and admitted the claim of plaintiff. Provided further that where defendant fails to file the written statement within said period of 30 days he shall be allowed to file the same on such other days as may be specified by the court for reasons to be recorded in writing, but which shall not be later than 90 days from date of service of summons. Order V Rule 2 of the Code of Civil Procedure also provides that every summons shall be accompanied by a copy of the plaint or, if so permitted, by a concise statement. Rules relating to service of summon. 1. Personal service. Order V Rule 10 of Code of Civil Procedure provides that service of summons shall be made by delivering or tendering a copy thereof, signed by the judge or such officer as he appoints in this behalf, and sealed with the seal of the court. According to Rule 12 of Order V of the Code of Civil Procedure, wherever it is practicable, service shall be made on the defendant in person, unless he has an agent empowered to accept service, in which case the service on such agent shall be sufficient. Order V Rule 15 of the Code of Civil Procedure provides that where in any suit the defendant is absent at the time when the service of summons is sought to be effected on him at this residence, and there is no likelihood of his being found at the residence within a reasonable time, and he has no agent empowered to accept service of the summons on his behalf, service may be made on any adult member of the family, whether male or female, who is residing with him. 2. Service by affixation. Order V Rule 17 of Code of Civil Procedure provides this mode of service. According to it, where the defendant or his agent or such other person, as aforesaid, i.e., the adult member of this family, refuses to sign the acknowledgement, or where the serving officer, after using all due and reasonable diligence, cannot find the defendant who is absent from his residence at the time when service is sought to be effected on him at his residence within a reasonable time, and there is no agent empowered to accept service of the summons on his behalf, nor any other person on whom the service can be made, the serving officer shall affix a copy of summons on the outer door or some other conspicuous part of the house in which the defendant ordinarily resides, or carries on business, or personally works for gain, and shall then return the original to the court from which it was issued, with a report endorsed thereon or annexed thereto, stating that he has so affixed the copy, the circumstances under which he did so. 3. Service by registered post. Rule 12- has been added to Order V of the Code of Civil Procedure by the Amendment Act of 1976, and it provides for simultaneous issue of summons for service by post in addition to personal service. It lays down that the court shall, in addition to and simultaneously with the issue of summons for service, also direct the summons to be served by registered post, acknowledgement due, addressed to the defendant or his agent empowered to accept the service at the place where the defendant or his agent actually and voluntarily resides or carries on business or personally works for gain. Subrule 2 of Rule 12- of the said order we lays down that when an acknowledgement purporting to be signed by the defendant or his agent is received by the court, or the postal article containing the summons is received back by the court with an endorsement purporting to have been made by a postal employee to the effect that the defendant or his agent had refused to take delivery of the postal article containing the summons when tendered to him, the court issuing the summons shall declare that the summons had been duly served on the defendant. 4. Delivery of summons by court. Wide Amendment Act No. 22 of 2002, Rule 9 of Order 5 has been amended, which provided delivery of summons by court. Rule 9 inter alia says that where defendant resides within the jurisdiction of court in which suit is instituted, or has an agent resident within that jurisdiction who is empowered to accept the summon, it shall, unless court otherwise directs, be delivered to proper offices, to be served by him or to such courier services as all approved by the court. 5. Service by courier. Sub-Rule 3, as amended in year 2002, says service of summons may be made by delivering or transmitting a copy thereof by registered post AD or by speed post or by such courier services as approved by High Court or court referred in Sub-Rule 1. However, service of summons under this rule shall be made at the expense of plaintiff. 6. Substituted service. Order V. Rule 20 of the Code of Civil Procedure provides for substituted service. It lays down that where the court is satisfied that there is no reason to believe that the defendant is keeping out of the way for the purposes of avoiding service, or that for any other reasons the summons cannot be served in the ordinary way, the court shall order the summons to be served by affixing a copy thereof in some conspicuous part of the house, if any, and in which the defendant is known to have last resided or carried on business or personally worked for gain, or in such other manner as the court thinks fit. Subrule 1A added to the said rule by the Amendment Act of 1976 further provides that where the court acting under Subrule 1 orders service by an advertisement in a newspaper, the newspaper shall be a daily newspaper circulating in the locality in which the defendant is last known to have actually and voluntarily resided, carried on business, or personally worked for gain. 7. Service on soldiers, sailors or airmen. Rule 28 of Order V of the Code of Civil Procedure provides that where the defendant is a soldier, sailor or airman, the court shall send the summons for service to his commanding officer, together with a copy to be retained by the defendant. 8. Service on corporation. Order XXIX Rule 2 of the Civil Procedure Code deals with service on corporation. It provides that where the suit is against a corporation, the summons may be served a. on the secretary, on any director, or other principal officer of the corporation, or b. by leaving it or sending it by post addressed to the corporation at the registered office, or if there is no registered office, then at the place where the corporation carries on business. 9. Service on defendant resides within the jurisdiction of another court. Service of summons on the defendant who resides within the jurisdiction of another court is to effected in accordance with Rule 25 Order V the Code of Civil Procedure. It provides that a summons, in such a case, may be sent by the court by which it is issued, whether within or without the state, either by one of its officers or by post to any court having jurisdiction in the place where the defendant resides. 10. Service on defendant residing out of India. Service on the defendant residing out of India and having no agent in India is to be effected in accordance with the provisions of Rule 25 of Order V of Code of Civil Procedure. It provides that where the defendant resides out of India has no agent in India and empowered to accept service, the summons shall be addressed to the defendant at the place where he is residing and sent to him by post, if there is postal communication between such place and the place where the court is situate. Q. 37. What is meant by pleadings? Briefly state the object and fundamental rules regarding pleadings. Ans. Pleadings. Order 6 Rule 1 of Code of Civil Procedure provides that pleading shall mean plaint or written statement. So pleadings are statements in writing, filed by each party to a case stating what his contention will be at the trial and giving all such details as his opponent needs to know in order to prepare his case in answer. Plaint is the statement of claim in writing and filed by plaintiff in which he sets out his cause of action with all necessary particulars, and written statement is the statement of defense in writing and filed by defendant in which he deals with every material facts alleged by plaintiff in the plaint and also states any new facts which may be in his favor including legal objections. Order 6 Rule 2 of Code provides that every pleading shall contain, and contain only, a statement in a concise form all material facts on which the party pleading relies for his claim or defense as the case may be, but not the evidence by which they are to be proved, and shall as and when necessary be divided into paragraphs numbered consecutively. Object of pleadings. The whole object of pleadings is to bring parties to definite issues and to diminish expense and delay and to prevent surprise at the hearing. In Ganesh Trading Co. v. Moji Ram, AIR 1979 SC 484 it was observed. Provisions relating to pleadings in civil case are meant to give to each side intimation of the case of the other so that it may be met, to enable courts to determine what is really at issue between parties, and to prevent deviations from the course which litigation on particular causes of action must take. Rules regarding pleadings. The Code of Civil Procedure lays down the following rules regarding pleadings of the parties. I. Pleading must state the material facts on which the party relies and not evidence. Order 1 Rule 2. 1. 2. The facts should be stated in the form of a concise statement and shall be divided into paragraphs numbered consecutively. Order 6 Rule 2. 2. CPC. 3. In the pleadings, dates, sums and numbers shall be expressed in figures as well as in words. Order 6 Rule 2. 3. CPC. 4. In all cases in which the party relies on any misrepresentation, fraud, breach of trust, willful default, and undue influence, and in all other cases in which particulars may be necessary, they should be stated with dates and items in the pleadings. Order 6 Rule 4 CPC. Any condition precedent, the performance of occurrence of which is intended to be contested, shall be distinctly specified in the pleading by the plaintiff or defendant, as the case may be, and all conditions precedent necessary for the case of the plaintiff or defendant shall be implied in his pleading and, therefore, such conditions need not be alleged specifically. Order 6 Rule 6 CPC. 6. Where the contents of any document are material, it shall be sufficient in any pleadings to state the effect thereof as briefly as possible without setting out the whole or any part thereof, unless the precise words of the document or any part thereof are material. Order 6 Rule 9 CPC 7. Wherever it is material to allege malice, fraudulent intention, knowledge or other condition of the mind of any person, it shall be sufficient to allege the same as a fact without setting out the circumstances from which the same is to be inferred. Order 6 Rule 10 CPC 8. Wherever it is material to allege notice to any person of any fact, matter or thing, it shall be sufficient to allege such notice as a fact, unless the form of the precise term of such notice, or the circumstances from which such notice is to be inferred, are material. Order 6 Rule 11 CPC 9. Whenever any contract or any relation between any person is to be implied from a series of letters or conversations, or otherwise from a number of circumstances, it shall be sufficient to allege such contract or relation as a fact, and to refer generally to such letters, conversations, or circumstances without setting them out in detail. Order 6 Rule 12 CPC Smiley facts which the law presumes need not be pleaded. Order 6 Rule 13 11. Legal pleas such as estoppel, limitation, and res judicata may be pleaded. 12. Every pleading shall be signed by the party and his pleader, if any. Order 6 Rule 14 CPC 13. Every pleading shall be verified at the foot by the party or by one of the parties' pleadings. Order 6 Rule 15 CPC Q. 38. What are the powers of the court to allow amendment of pleadings? Ans. General rule of pleadings is that all the material facts and necessary particular must be stated in the pleadings, and decision cannot be based on grounds outside the pleadings. But many a time the party may find it necessary to amend his pleadings before or during trial of the case. Rule 17 of Order 6 CPC provides for amendments of pleading. It reads as under. The court may at any stage of proceedings allow either party to alter or amend his pleadings in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between the parties. Civil Procedure Code, Amendment, Act, 2002 has inserted proviso to Rule 17 of Order 6 of Code which says, provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. So the object of the rule is that the courts should try the merits of case that come before them and should consequently allow all amendments that may be necessary for determining the real question in controversy between the parties, provided it does not cause injustice or prejudice to other side. Therefore, main points to be considered before a party is allowed to amend his pleadings are: firstly, whether the amendment is necessary for determination of real question in controversy, and secondly, can the amendment be allowed without injustice to other side. However, in following cases, court is justified in refusing to amend pleadings. A. Leave to amend will be refused where the amendment is not necessary for the purpose of determining the real question in controversy. B. Leave to amend will be refused if it introduces a totally different and a new and inconsistent case or changes the fundamental character of case. C. Leave to amend will be refused where the effect of proposed amendment is to take away from other side a legal right accrued in his favor by lapse of time, or when leave to amend pleadings is not made in good faith. Recently, Supreme Court in BK Pillai v. P. Pillai, AIR 2000 SC 614 has observed All amendments of pleadings should be allowed which are necessary for determination of real controversy in suit provided proposed amendment does not alter or substitute new cause of action or proposed amendment should not cause such prejudice which cannot be compensated by cost. Q39. What do you understand by plaint and written statement? What are particulars which are required to be contained in plaint and written statement? Ans. Plaint is statement of claim, a document by presentation of which the suit is instituted. Order 7 Rules 1 to 5 CPC say that plaint should contain following particulars. A. Name of the court in which suit is brought. B. Name, description and place of residence of plaintiffs and defendants. C. Facts constituting the cause of action and when it arose. D. Facts showing that court has jurisdiction. E. Statement of value of subject matter of suit for the purpose of court fee. F. Relief claimed by plaintiff. G. Where the plaintiff or defendant is minor or person of unsound mind, statement to this effect. H. Where plaintiff has allowed set off or relinquished any portion of his claim, the amount so allowed or relinquished. I. If subject matter of suit is immovable property, description of such property for identity. J. If the suit is time barred, the grounds upon which the exemption from law of limitation is claimed. In view of Civil Procedure Code, Amendment, Act 2002, Rule 9 of Order 7 has been amended. Now, it provides procedure on admitting plaint, where the court orders that the summons be served on defendants in the manner provided in Rule 9 of Order 5. It will direct the plaintiff to present as many copies of the plaint on plain paper as there are defendants within 7 days from the date of such order along with requisite fee for service of summons on defendants. Order 7 Rule 10C.P.C says that where at any stage of suit, court finds that it has no jurisdiction either territorial or pecuniary or with regard to subject matter of suit, it will return the plaint to be presented to proper court. Order 7 Rule 11 says that plaint will be rejected in following cases. A. Where plaint does not disclose the cause of action. A. Where relief claimed is undervalued and valuation is not corrected within the time fixed by court. C. Where plaint is insufficiently stamped and plaintiff fails to pay requisite court fee fixed by court. D. Where suit appears to be barred by law. Following ground were added Wide Amendment Act of 1999 and 2002. In Rule 11 of Order 7 one ground is added as E. Where it is not filed in duplicate. F. Where plaintiff fails to comply with provisions of Rule 9 written statement. Written statement is pleading of defendant wherein he deals with every material fact alleged by plaintiff in his plaint and also states any new fact in his knowledge and takes legal objections against the claim of plaintiff. Civil Procedure Code, Amendment, Act 2002 has amended Rule 1 of Order 8 of Code in following words. The defendant shall within 30 days from the date of service of summons on him, present a written statement of his defense. Provided that where defendant fails to file the written statement within said period of 30 days, he shall be allowed to file the same on such other day as may be specified by the court, for reasons to be recorded in writing, but which shall not be later than 90 days from the date of service of summons. Order 8 Rule 1 to 5 and 7 to 10C.P.C provides as to particulars to be contained in a written statement. A. Defendant may take any number of defenses either simply or alternatively, even though they may be inconsistent provided they are maintainable at law. B. New facts such as the suit is not maintainable or that transaction is either void or voidable, and all such defenses as, if not raised, would take the plaintiff by surprise must be raised. C. Defendant is bound to produce all the documents in support of his defense or his claim to set off or counter-claim which are in his possession. D. Where defendant wants to deny any allegation of fact in the plaint, he must do so clearly and specifically. Every allegation of fact in plain, if not specifically or by necessary implication, shall be taken as admitted except as against a person under disability. Court may, however, require the proof of any such fact otherwise than by such admission. Wide Amendment Act of 2002 Sub-Rule 3 is amended in Rule 1 of Order 8 of Code as a document which ought to be produced in court by the defendant under this rule, but is not so produced shall not, without the leave of the court, be received in evidence on his behalf at the hearing of the suit. Wide Amendment Act 2002, Rule 9 and 10 to Order 8 have been amended in following words. 9. Subsequent pleadings. No pleading subsequent to the written statement of a defendant other than by way of defense to set off or counterclaim shall be presented except by the leave of the court and upon such terms as the court thinks fit, but the court may at any time require a written statement or additional written statement from any of the parties and fix a time of not more than 30 days for presenting the same. 10. Procedure when party fails to present written statement called for by court, where any party from whom a written statement is required under Rule 1 or Rule 9 fails to present the same within the time permitted or fixed by the court, as the case may be, the court shall pronounce the judgment against him, or make such order in relation to the suit as it thinks fit, and on the pronouncement of such judgment a decree shall be drawn up. Q. 40. A. When can a plaint be returned for presentation to another court? B. When can court reject the plaint? Ans. A. Return of plaint. Order 10 Rule 1 of Code of Civil Procedure says, subject to the provisions of Rule 10-A, the plaint shall at any stage of the suit be returned to be presented to the court in which the suit should have been instituted. Rule 1(2) says, on returning a plaint, the judge shall endorse thereon the date of its presentation and return the same of the party presenting it, and a brief statement of reasons for returning it. In Amar Chand v. Union of India, AIR 1973 SC 313, it was observed that when the plaint is filed in proper court after getting it back from the wrong court, it cannot be said to be continuation of suit. Suit must be deemed to be presented when it is filed in proper court. By Order 7, Rule 10- of the Code of Civil Procedure, it has been provided that where, in any suit, after the defendant has appeared, the court is of opinion that the plaint should be returned, it shall, before doing so, intimate this decision to the plaintiff, and the plaintiff, on receiving such intimation, may make an application to the court, A. Specifying the court in which he proposes to present the plaint after its return, B. Praying that the court may fix a date for the appearance of the parties in the said court, and C. Requesting that the notice of the date so fixed may be given to him and to the defendant. Sub-Rule 3 of Rule 10- of the Code lays down that where an application is made by the plaintiff, the court shall, before returning the plaint, and notwithstanding that the order for return of plaint was made by it on the ground that it has no jurisdiction to try the suit, A. Fix a date for the appearance of the parties in the court in which the plaint is proposed to be presented, and B. Give to the plaintiff and to the defendant notice of such date for appearance. Subrule 4 of this rule further provides that where the notice of the date for appearance is given, it shall not be necessary for the court in which the plaint is presented after its return to serve the defendant with a summons for appearance in the suit, unless that court, for reasons to be recorded, otherwise directs, and the said notice shall be deemed to be a summons for the appearance of the defendant in the court in which the plaint is presented on the date so fixed by the court by which the plaint was returned. Rule 10-B of Order 7 of the Code of Civil Procedure deals with the power of appellate court to transfer suit to the proper court. It provides that where, on an appeal against an order for the return of plaint, the court hearing the appeal confirms such order, the Court of Appeal may, if the plaintiff by an application so desire, while returning the plaint, direct plaintiff to file the plaint, subject to the provisions of the Limitation Act, 1963, in the court in which the suit should have been instituted, whether such court is within or without the state in which the court hearing the appeal is situated, and fix a date for the appearance of the parties in the court in which the plaint is directed to be filed, and when the date is so fixed it shall not be necessary for the court in which the plaint is filed to serve the defendant with the summons for appearance in the suit, unless that court in which the plaint is filed, for reasons to be recorded, otherwise directs. B. Rejection of plaint. Rules 11 to 13 of Order 7 of Code of Civil Procedure deal with rejection of plaint. After the Amendment Act No. 22 of 2002, Rule 11 says plaint shall be rejected in following cases. A. Where it does not disclose a cause of action. B. Where the relief claimed is undervalued and the plaintiff, on being required by the court to correct the valuation within a time to be fixed by the court, fails to do so. C. Where the relief claimed is properly valued, but the plaint is returned upon paper insufficiently stamped and plaintiff, on being required by court to supply the requisite stamp paper within a time to be fixed by the court, fails to do so. D. Where the suit appears from the statement in the plaint to be barred by any law. E. Where it is not filled in duplicate. F. Where the plaintiff fails to comply with the provisions of Rule 9. Procedure on rejection of plaint, Rule 12. Where a plaint is rejected, the judge shall record an order to that effect with the reasons for such order. Effect of rejection of plaint. Rule 13. If the plaint is rejected on any of the above grounds, the plaintiff is not thereby precluded from presenting a fresh plaint in respect of the same cause of action. An order rejecting a plaint is a decree within the meaning of Section 2(2) of the Code, and therefore is appealable also. Q. 41. What do you understand by set-off? Distinguish between the legal and equitable set-off. Ans. When the plaintiff files a suit for recovery of money and the defendant pleads liability of the plaintiff to pay to him, such a plea is called set-off. Thus, in an action to recover money, a set-off is a cross-claim by the defendant, for which he might maintain an action against the plaintiff. Order 8 Rule 6 CPC provides that only a set-off which is for ascertained sum of money legally recoverable by the defendant from the plaintiff within the pecuniary jurisdiction of the court is permissible, and both the parties must fill the same character as they fill in the plaintiff's suit. It has also been provided in it that the defendant may, at the first hearing of the suit, but not afterwards, unless permitted by the court, present a written statement containing the particulars of the debt sought to be set off. The following are the essential conditions of legal set-off. I. The suit must be for recovery of money. 2. The amount claimed to be set off must be an ascertained sum of money. 3. It must be legally recoverable from the plaintiff, i.e., it is not barred by time, etc. 4. It must not exceed the pecuniary limits of the jurisdiction of the court. It must be recoverable by the defendant or by all the defendants, if there are more than one. 6. It must be recoverable by the defendant from the plaintiff or all the plaintiffs, if there are more than one. 7. Both the parties must fill the same character as they fill in the plaintiff's suit. Equitable set off means a set off of an ascertained sum of money arising out of cross demands, arising out of the same transaction in cases of debits and credits, in cases in which cross demands arise out of the same transaction or are so connected in their nature and circumstances as to make it inequitable that the plaintiff should recover and the defendant driven to a cross suit. Courts have allowed a set-off even though the amount may be an unascertained sum, and such set-off are known as equitable set-off. Legal set-off has been recognized by Order 6 Rule 6 of the Code of Civil Procedure and can be raised as of right, but no provisions for equitable set-off has been made in the Code of Civil Procedure and it cannot be claimed as a matter of right. Distinction between legal and equitable set-off. Following are the main distinctions between the legal and equitable set-off. A. Legal set-off is for an ascertained sum of money, while equitable set-off may be allowed in respect of an unascertained sum of money. B. In case of legal set-off, cross demand may or may not arise from the same transaction, but in equitable set-off, the cross demands must arise out from the same transaction. C. In case of legal set-off, the court is bound to entertain and adjudicate upon it because it has been provided in Order 8 Rule 6 of Code and can be raised as of right, while in case of equitable set-off it is not obligatory on the part of the court to adjudicate upon it. D. In a legal set-off, the amount claimed must be legally recoverable and not barred by limitation at the date of suit, but claim by way of equitable set-off can be allowed even if it is based by limitation on date of suit where there is a fiduciary relationship between plaintiff and defendant. E. For legal set-off, court fee is to be paid, but it is not to be paid in case of equitable set-off. Q. 42. What do you understand by set-off and counterclaim? What is the difference between the two? Ans. Set-off. Order 8 Rule 6C.P.C. A plea of set-off is a plea whereby defendant acknowledges the justice of plaintiff's demand but sets up another demand of his own to counterclaim that of plaintiff either wholly or in part. Where in a suit for recovery of money by plaintiff, defendant finds that he has also a claim of some amount against the plaintiff, he can claim a set-off in respect of said amount. A defendant may claim set-off if following conditions are satisfied. A. Suit must be for recovery of money. B. Sum of money must be ascertained. C. Such sum must be legally recoverable. D. It must be recoverable by defendant from plaintiff. E. It must not exceed the pecuniary limits of the court in which the suit is brought. F. Both the parties must fill in defendant's claim to set off the same character as they fill in plaintiff's suit. Counterclaim. Counterclaim may be defined as claim made by defendant in the suit against plaintiff. Thus, counterclaim is substantially a cross-action. In Lakshmi Das v. Nana Bhai, AIR 1964 SC 11, Supreme Court held that right to make counterclaim as statutory right and held that court has power to treat the counterclaim as cross-suit and hear the original suit and counterclaim together if counterclaim is properly stamped. Wide Amendment Act 1976 Rule 6-A to 6-G were added in Order 8 CPC Rule 6A. 1. Provides that defendant may set up by way of counter-claim against the claim of plaintiff any right or claim in respect of cause of action accruing to defendant against plaintiff either before or after filing of suit but before the defendant has delivered his defense or before the time fixed for delivery of his defense has expired. Set-off and counter-claim distinction. A. Set-off is statutory defense against plaintiff's action, and counter-claim is substantially a cross-action. B. Set-off must be for ascertained sum or it must arise out of same transaction. A counter-claim need not to arise out of the same transaction. C. In case of set-off the amount must be recoverable at the date of suit, while in case of counterclaim the amount must be recoverable at the date of filing written statement. D. When defendant demands in a plaintiff's suit an amount below or up to that of suit, it is set off, but when it is for larger amount, the claim for excess amount is counterclaim. Q. 43 discuss the provisions of Code of Civil Procedure relating to dismissal of suit for non-appearance of parties. Ans. Order 9 of the Code of Civil Procedure deals with the appearance of parties and consequences of non-appearance. Order 9 Rule 1 of the Code of Civil Procedure provides that on the date fixed in the summons for the defendant to appear and answer, the parties shall be in attendance at the courthouse in person or by their respective pleaders, and the suit shall then be heard unless the hearing is adjourned to a future day fixed by the court. Dismissal of suit. The court may dismiss the suit on the date fixed for hearing if A. The summons is not served upon the defendant in consequence of failure of the plaintiff to pay the court fee or postal charges, if any, chargeable for such service or to present copies of the plaint or concise statement as required by Rule 9 of Order 7 of the Code of Civil Procedure. Order 9 Rule to CPC. B. Neither party appears when the suit is called for hearing. Order 9 Rule 3 CPC. C. After a summons has been issued to the defendant or to one of several defendants and returned unserved, the plaintiff fails for a period of 1 month from the date of the return to apply for the issue of a fresh summons unless the plaintiff has within the said period satisfied the court that I. He has failed after using his best endeavors to discover the residence of the defendant who has not been served, or 2. Such defendant is avoiding of process, or 3. There is any sufficient cause for extending the time. Order 9 Rule 5 CPC. D. The defendant appears and the plaintiff does not appear when the suit is called out for hearing unless the defendant admits the claim or part thereof. Order 9 Rule 8 CPC. Q. 44B was an occupation of a house belonging to A. In March 1981, I had filed suit for possession alleging that B was a trespasser in the house. The suit was contested by B, who pleaded that he had become the owner of the house by adverse possession. The suit was fixed for hearing on 15th July 1981, on which date B appeared in the court, but A was unable to attend and the suit was dismissed in default. On the 10th December 1981, B died, leaving behind his widow C. In January 1982, A brought a suit against C alleging that she is in illegal possession of the house and praying that a decree for possession he passed against her. Advise C if the suit is barred. Give reasons. Ans. After having gone through the facts of case in hand, following issue is framed: whether A's suit against C, B's wife, is on the same cause of action as was A's earlier suit against B, which dismissed in default. Order 9 Rule 8 of CPC provides that where the defendant appears and plaintiff does not appear, and the defendant does not admit the plaintiff's claim wholly or partly, the court shall pass an order dismissing the suit. Order 9 Rule 9 CPC then provide 1. Where a suit is wholly or partly dismissed under Rule 8, the plaintiff shall be precluded from bringing a fresh suit in respect of same cause of action. But he may apply for an order to set the dismissal aside, and if he satisfies the court that there was sufficient cause for his non-appearance when the suit was called on for hearing, the court shall make an order setting aside the dismissal upon such terms as to costs or otherwise as it thinks fit, and shall appoint a day for proceeding with the suit. So, in view of provisions of Order 9 Rule 9, second suit cannot be brought when first has been dismissed under Rule 8 on same cause of action. In the case in hand, it is admitted fact that A's earlier suit against B was for possession on the ground that B was trespasser. That suit was dismissed under Order 9 Rule 8 as A could not appear in court on 15th July 1981. So A is precluded from bringing a suit again on same cause of action in view of Order 9 Rule 9. The expression cause of action means all those facts which are necessary for a plaintiff to prove in a suit to get judgment of court in his favor, or every one of those facts which if not proved would give the defendant the right of judgment of court. In Mohd Khalil Khan and others v. Mehboob Ali Mia 75 I 121, the Privy Council had observed, in considering whether the cause of action in subsequent suit is the same or not as the cause of action in previous suit, the tests to be applied is, are the causes of action into suits in substance not technically identical? In case in hand, plaintiff A had filed the earlier suit for possession of house against B, which was dismissed in default. Thereafter, A never filed any application for setting aside the order of dismissal of suit. Later B died, leaving behind his widow, C. A has again filed suit against C for possession of that very house on the ground that he is owner of suit property, and widow C is trespasser therein. Such suit attracts Art. 65 of Limitation Act, and onus is on C to establish that she was in adverse possession of said property. Now question is whether C can take the same plea which B had taken in earlier. It is well established that the expression the possession of defendant under Article 65 includes also the possession of person from or through whom the defendant derived his liability to be sued, and as such defendant is entitled to take his possession with that of his predecessor in interest for the purpose of computing the statutory period of limitation. Applying the aforesaid law to the facts of case in hand, it is clear that defendant C is claiming her right to adverse possession through her late husband B, and the necessary conclusion is that the cause of action in both the suits is same, and thus present suit of A against C is barred by Order 9 Rule 9 CPC. Q. 45 in an eviction proceedings, 27th May 1989 was fixed for evidence of landlord and 2nd June 1989 for evidence of tenant. On 27th May 1989 neither tenant nor his counsel appeared at hearing. The court recorded evidence of landlord and passed ex parte eviction order. Same day tenant applied for setting aside the ex parte order, alleging that he was ill and his counsel had forgotten mentioning the case in his diary. He filed his affidavit but did not file medical certificate and diary and affidavit of counsel. The landlord rebutted his allegation on affidavit. Decide the application. Ans. Order 9 Rule 6 of Civil Procedure Code provides regarding ex parte proceedings and lays down that, where plaintiff appears and defendant does not appear, the plaintiff has to prove service of summons on defendant. If service of summons is proved, the court may proceed ex parte against defendant and may pass decree in favor of plaintiff if the plaintiff proves his case. So when defendant has not appeared on date of hearing of case, and plaintiff appears and proves the service of summons on defendant, then court can proceed with the case ex parte and pass decree in favor of plaintiff, if he proves his case. The defendant against whom an ex parte decree has been passed has the following remedies. A. He can apply to court by which such decree is passed to set it aside. Order 9 Rule 13. B. Prefer appeal against such decree. Section 96, 2. C. Apply for review. Order 47 and Section 114. D. File suit on ground of fraud. That being the legal position, coming now to case in hand, it is admitted that 27th May 1989 was fixed for evidence of landlord and 2nd June 1989 was fixed for recording evidence of tenant. However, on 27th May 1989 defendant, tenant, did not appear nor his counsel appeared in court, and thus court proceeded ex parte and after recording plaintiff's evidence passed ex parte eviction decree against tenant on 27-5-1989. On that very day, i.e. 27-5-89, tenant applied under Rule 13 Order 9 for setting aside above said ex parte eviction decree on the ground that he was ill and his counsel had forgotten to mention the case in his diary. Rule 13 of Order 9 CPC provides that if defendant satisfies the court that he was prevented by sufficient cause from appearing on date of hearing of case, court will set aside decree passed against him. However, expression sufficient cause has not been defined. Thus every case has to be seen in light of peculiar facts of case. Supreme Court recently in G.P. Srivastava v. R.K. Raizada AIR 2000 SC 1221 has held. Under Order 9 Rule 13 CPC, an ex parte decree passed against defendant can be set aside upon the satisfaction of court that either summons were not duly served upon defendant or he was prevented by sufficient cause from appearing when suit was called for hearing. Words "was prevented by sufficient cause from appearing" must be liberally construed to enable the court to do complete justice between parties. Sufficient cause for the purpose of O9R 13 CPC has to be construed as elastic expression for which no hard and fast rule can be laid down. Keeping in view above observations, coming now to case in hand, defendant has taken the plea that he was lying ill on date of hearing of suit, i.e. 27th May 1989, for which he has filed affidavit though has not produced any medical certificate to substantiate his plea, and it is also pleaded that his counsel forgot to mention the case in diary and therefore his counsel could not appear. To prove this fact, affidavit of counsel and diary is produced. Plaintiff by way of affidavit has rebutted the plea taken by defendant. Considering the facts and keeping in view the observations of Supreme Court in this regard, it can be said that defendant had a sufficient cause which prevented him from appearing in court on relevant date. We should not insist on strict proof of fact of illness of defendant, and thus his application under Rule 13 of Order 9 CPC deserves to be accepted and ex parte eviction decree should be set aside. Q. 46 Plaintiff could not reach the court on the date fixed, so his suit was dismissed for default. Advise the plaintiff as to steps he should take. Ans. Order 9 Rule 8 CPC provides, where the defendant appears and the plaintiff does not appear when the suit is called on for hearing, the court shall dismiss the suit, unless the defendant admits the claim, or part thereof, in which case the court shall pass a decree accordingly. Order 9 Rule 9 CPC further provide, on such dismissal of the suit, the plaintiff is precluded from bringing a fresh suit in respect of the same cause of action, but he may apply for an order to set the order of dismissal aside. The court shall, After issuing notice of the application to the other side and on being satisfied that there was sufficient cause for non-appearance, set aside the dismissal on payment of costs or on other terms as it thinks fit. In Lakshmi Commercial Bank v. Hans Raj AIR 1981 P&H to 28 it was observed. In deciding whether a suit dismissed for default be restored, what has really to be considered is whether the plaintiff was really trying to appear on the day fixed. If sufficient cause is shown by the plaintiff for his non-appearance, court may restore the suit. What is sufficient cause depends upon facts and circumstances of each case, and liberal and generous construction should be adopted to advance the cause of justice, and restoration should not ordinarily be denied. Q. 47. What is the provision of examination of the parties by the court? Ans. Order X of Code of Civil Procedure deals with the examination of parties by the court. Order 10 Rule 1 provides that the court shall, at the first hearing the suit, ascertain from each party or his pleader whether he admits or denies such allegations or facts as are made in the plaint or in the written statement, if any of the opposite party. After the Amendment Act No. 46 of 1999, Rule 101-B and 1-C has been added in Order X of Code. Rule 1 says after recording the admission and denials, the court direct the parties to suit to opt either mode of settlement outside the court as specified in subsection 1 of Section 89. On the option of the parties, the court shall fix the date of appearance before such forum or authority as may be opted by the parties, and Rule 1-B says that parties shall appear before such forum or authority. Rule 1-C says that if the presiding officer of conciliation forum or authority is satisfied that it would not be proper in interest of justice to proceed with the matter, he shall refer the matter again to the court. Rule 2 provides for oral examination of the parties to the suit with a view to elucidating matters in controversy in the suit. The court thus ascertains with precision the propositions of law or fact on which the parties are at variance, and on such question issues are required to be framed. Rule 3 then says that substance of the examination shall be reduced to written by judge, which shall form part of record. Then Rule 4 lays down the consequence of refusal or inability of pleader to answer and provides that where pleader or any person accompanying a pleader as referred to in Rule 2 refuses to or is unable to answer any material question relating to suit which in opinion of court be answered by party, court shall postpone the hearing of suit and direct such party to appear in person on such date as fixed. Q. 48. What do you understand by discovery? What is its object and who can apply for it? Ans. Discovery means to compel the opposite party to disclose what he has in his possession. Order 11 of Code Civil Procedure deals with discovery and inspection. Discovery means to find out material facts and documents from an adversary in order to ascertain nature of the case and to narrow down the points in issue or to avoid proving admitted facts. Kinds of discovery. Discovery is of two kinds. I. Discovery by interrogatories. 2. Discovery documents. I. Discovery by interrogatories. Order 11 Rule 1 of the Code of Civil Procedure deals with discovery of interrogatories, and it provides that in any suit the plaintiff or defendant, by leave of the court, may deliver interrogatories in writing for the examination of the opposite parties or any one or more of such parties, and such interrogatories when delivered shall have a note at the foot thereof stating which of such interrogatories each of such person is required to answer. Provided that no party shall deliver more than one set of interrogatories to the same party without an order for that purpose. provided also that interrogatories, which do not relate to any matter in question in the suit shall be deemed irrelevant, notwithstanding that they might be admissible in the oral cross-examination of a witness. Rule 2 of Order 11 of the Code of Civil Procedure provides that on an application for leave to deliver interrogatories, the particular interrogatories proposed to be delivered shall be submitted to the court. In deciding upon such application, the court shall take into account any offer, which may be made by the party sought to be interrogated to deliver particulars, or to make admissions, or to produce documents relating to the matters in question, or any of them, and leave shall be given as to such only of the interrogatories has been laid down in Raj Narayan v. Indira Gandhi, AIR 1972 SC 1302. It was observed that interrogatories can be allowed whenever the answer to them will serve either to prove the case of party administering the interrogatories or to destroy the case of his adversary. The right is a valuable one and the party should not lightly be deprived of that right and must be exercised liberally as to shorten litigation, save expenses, and serve the ends of justice. Rule 6 of Order 11 of the Code of Civil Procedure deals with the objections to interrogatories. It provides that any objection to answer any interrogatory on the ground that it is scandalous or irrelevant or not exhibited bona fide for the purpose of the suit, or that the matters inquired into are not sufficiently material at that stage, or on the ground of privilege, or on any other ground, may be taken in the affidavit in answer. According to Rule 8 of Order 11 of the Code, interrogatories shall be answered by affidavit to be filed within 10 days or within such other time as the court may allow. Discovery of documents. Rules 12 to 14 of Order 11 of the Code of Civil Procedure deal with the discovery of documents. All documents relating to the matters in issue in the possession or power of any adversary can be inspected by means of discovery of documents. Rule 12 of Order 11 of the Code of Civil Procedure provides that any party may, without filing any affidavit, apply to the court for an order directing any other party to any suit to make discovery on oath of the documents which are or have been in his possession or power, relating to any matter in question therein. On the hearing of such application, the court may either refuse or adjourn the same, if satisfied that such discovery is not necessary or not necessary at the stage of the suit, or make such order, either generally or limited to certain classes of documents, as may in its discretion to thought fit, provided that discovery shall not be ordered when and so far as the court shall be opinion that it is not necessary either for disposing fairly of the suit or for saving costs. Rule 13 of Order 11 of the Code of Civil Procedure provides that the affidavit to be made by a party against whom an order for making discovery of documents is made by the court shall specify which of the documents therein mentioned he objects to produce, and it shall be in Form Number 5 in Appendix C, with such variations as circumstances may require. It has further been provided in Rule 14 of the said order that it shall be lawful for the court, at any time, during the pendency of any suit, to order the production by any party thereto, upon oath, of such of the documents in his possession or power, relating to any matter in question in such suit, as the court shall think right, and the court may deal with such documents, when produced, in such manner as shall appear just. Q. 49. What is meant by issue and how they are to be framed? Ans. Order 14 of the Code of Civil Procedure deals with settlement of issues and determination of suit on issues of law on issues agreed upon. Rule 1 of Order of the Code of Civil Procedure provides that issues arise when a material proposition of fact or law is affirmed by the one party and denied by the other. Material propositions are those propositions of law or fact which a plaintiff must allege in order to constitute his defense. Such material proposition affirmed by one party and denied by the other shall form the subject of a distinct issue. According to Subrule 4 of Rule 1 of Order 14 of the Code of Civil Procedure, issues are of two kinds. A. Issues of fact. B. Issues of law. Subrule 5 of Rule 1 of Order 14 of the Code of Civil Procedure further provides that at the first hearing of the suit, the court shall, after reading the plaint and the written statements, if any, and after examination under Rule 2 of Order X and after hearing the parties or their pleaders, ascertain upon what material propositions of fact or of law the parties are at variance, and shall thereupon proceed to frame and record those issues on which the right decision of the case appears to depend. In Sita Ram v. Radha Bai, AIR 1964 SC 497, it was observed that issues are the backbone of a suit. Framing of issue has a very important bearing on the trial and decision of case. Firstly, because it is issues framed and not the pleadings that guide the parties in matter of leading evidence. Secondly, the court cannot refuse to decide the point on which issue has been framed. Thirdly, court should not frame issue which does not arise in pleadings. Materials for framing issues. According to Order 14 Rule 3 of the court may frame the issues from all or any of the following materials. A. Allegations made on oath by the parties, or by any person present on their behalf, or made by the pleaders of such parties. B. Allegations made in the pleadings or in answers to interrogatories delivered in the suit. C. The contents of documents produced by either party. In addition to the said material, the other material which may be considered in framing issues are the answer to interrogatory statements made by parties or their representatives, when examined under Order X of the Code of Civil Procedure, an examination of a witness or any document ordered to be produced under Order 14 of the Code of Civil Procedure. Rule 4 of Order 14 of the Code of Civil Procedure provides that where the court is of opinion that the issues cannot be correctly framed without the examination of some person not before the court or without the inspection of some document not produced in the suit, it may adjourn the framing of the issue to a future day, and may, subject to any law for the time being in force, compel the attendance of any person or the production of any document by the person in whose possession or power it is, by summons of other process. Q. 50. What is the effect of omission of framing an issue? Whether a court is empowered to amend or strike out an issue. Ans. Omission to frame issue in Keval Krishan v. Dinanath, AIR 1993 SC 881, it was observed that even though it is the duty of the court to frame proper issues, mere omission to frame an issue is not necessarily fatal to the suit. Omission to frame an issue is an irregularity which may or may not be a material one. If such omission affects the disposal of the suit on merits, the case must be remanded to the trial court for a fresh trial. On the other hand, where the parties went to trial with full knowledge that a particular point was at issue, they have not been prejudiced and substantial justice has been done, absence of an issue is not fatal to the case so as to vitiate the proceedings. Power to amend and strike out issue. Rule 5 of Order 14 of the Code of Civil Procedure deals with this power of the court. It provides that the court may, at any time before passing a decree, amend the issue or frame additional issues on such terms as it thinks fit, and all such amendment or additional issues as may be necessary for determining the matters in controversy between the parties shall be so made or framed. The court may also, at any time before passing a decree, strike out any issues that appear to it to be wrongly framed or introduced. Q. 51. Is there any penalty in case of default of attendance of witness on the issue of summons? What are the consequences of refusal of a party to give evidence? Ans. The court has power to enforce the attendance of any person to whom a summons has been issued and for that purpose may a. Issue a warrant, with or without bail, for his arrest. B. Attach and sell his property. C. Impose a fine upon him not exceeding 500 rupees, or D. Order him to furnish security for his appearance and in default commit him to civil prison. The court may, where a person to whom summons has been issued fails to comply with it, without lawful excuse, issue a proclamation requiring him to attend at a time and place named therein before inflicting the penalties mentioned above. No court of small causes shall, however, make an order for the attachment of immovable property. Order 16, Rule 10. Where the person appears after the attachment of his property and satisfies the court that he did not fail to comply with the summons without lawful excuse or did not intentionally avoid service, or that he had no notice of the proclamation, the court may release the property from attachment. If the person, however, does not appear or appears but fails to satisfy the court may impose upon him fine not exceeding 500 rupees, having regard to his condition in life and the circumstances of the case, and attach and sell his property for the recovery of the same. Order 16, Rules 11 and 12. Consequence of refusal of party to give evidence. Where any party to a suit present in court refuses, without lawful excuse, when required by the court, to give evidence or to produce any document, then and there in his possession or power, the court may pronounce judgment against him or make such order in relation to the suit as it thinks fit. Order 16, Rule 20. Q. 52. When can adjournment be granted by court, and what are the consequences of failure of a party to produce evidence for which an adjournment was granted by court? Ans. Order 17, Rule 1, I of Code of Civil Procedure provides that court may, if sufficient cause is shown, at any stage of the suit, grant time to the parties or to any of them, and may from time to time adjourn the hearing of the suit for reasons to be recorded in writing. Wide Amendment Act No. 46 of 1999. A proviso is attached to Rule 1, I, which says, no such adjournment shall be granted more than 3 times to a party during hearing of the suit. So right of adjournment on showing sufficient cause has been limited to 3 times, so that suit may be disposed of expeditiously and no party to suit should seek adjournment as a delaying tactic. Subrule 2 of Rule 1 of Order 17 of the Code of Civil Procedure further provides that in every such case the court shall fix a day for the further hearing of the suit, and may make such order as it thinks fit with respect to the costs occasioned by the adjournment. Order 17, Rule 3 of the Code of Civil Procedure deals with the power of the court to proceed with the case, notwithstanding either party fails to produce evidence. It provides that where any party to a suit to whom time has been granted fails to produce his evidence, or to cause the attendance of his witnesses, or to perform any other act necessary to the further progress of the suit, for which time has been allowed, the court may, notwithstanding such default, a. If the parties are present, proceed to decide the suit forthwith, or B. If the parties are, or any of them is absent, proceed under Rule 2. The main distinction between Rule 2 and 3 of Order 17 of the Civil Procedure Code is that a decree passed against the defendant under Rule 3 will not be an ex parte decree which can be set aside under Order 9 Rule 13 of the said code, while a decree passed under Rule 2 can be set aside under Order 9 Rule 13 of the code if the necessary requirements are fulfilled. Q. 53. Who has the right to begin the evidence at the hearing of the suit? Discuss the important amendment brought about in Order 18 of Code in this regard. Ans. Order 18 of Code of Civil Procedure deals with hearing and examination of witnesses. Order 18 Rule 1 of Code says that the plaintiff has right to begin unless the defendant admits the facts alleged by the defendant and contends that either in point of law or on some additional facts alleged by the defendant, the plaintiff is not entitled to any part of the relief which he seeks, in which case the defendant has the right to begin. It has further been provided in Rule 2 of Order 18 of the Code of Civil Procedure that on the date fixed for the hearing of the suit or on any other date to which the hearing is adjourned, the party having the right to begin shall state his case and produce his evidence in support of the issues which he is bound to prove. The other party shall then state his case and his evidence, if any, and any then address the court generally on the whole case, and the party beginning may then reply generally on the whole case. Sub-Rule 4 of Rule 2 of Order 18 of the Code of Civil Procedure, which has been inserted by the Amendment Act No. 104 of 1976, provides that notwithstanding anything contained in this rule, the court may, for reasons to be recorded, direct or permit any party to examine any witness at any stage. Rule 4 of Order 18 has been amended by the Amendment Act of 2002. Rule 4(I) of Order 18 says in every case the examination in chief of a witness shall be on affidavit, and copies thereof shall be supplied to the opposite party by the party who calls him for evidence. Provided that where documents are filled and the parties rely upon the documents, the proof and admissibility of such documents which are filled along with affidavit shall be subject to the order of the court. So, in order to expedite the trial of suit, provision for furnishing examination in chief of witnesses on affidavit has been made. Rule 4(2) says, the evidence, cross-examination and re-examination of the witness in attendance, whose evidence, examination in chief, by affidavit has been furnished to the court, shall be taken either by the court or by the commission appointed by it. Provided that the court may, while appointing a commission under this sub-rule, consider taking into account such relevant factors as it thinks fit. Q. 54. What is a judgment pronounced and when it may be altered or modified? What are its contents? Is there any time limit for pronouncing judgment? Ans. Section 33 of Code of Civil Procedure provides that the court, after the case has been heard, shall pronounce judgment, and on such judgment a decree shall follow. Order 20 of Code of Civil Procedure deals with judgment and decree. Wide Amendment Act No. 22 of 2002 in Rule 1 of Order 20, Sub-Rule 1, has been amended in following words. 1. The court, after the case has been heard, shall pronounce judgment in an open court, either at once or as soon thereafter as may be practicable, and when the judgment is to be pronounced on some future day, the court shall fix a day for that purpose, of which due notice shall be given to the parties or their pleaders. provided that where the judgment is not pronounced at once, every endeavor shall be made by the court to pronounce the judgment within 30 days from the date on which the hearing of the case was concluded, but where it is not practicable so to do on the ground of the exceptional and extraordinary circumstances of the case, the court shall fix a future day for the pronouncement of the judgment, and such day shall not ordinarily be a day beyond 60 days from the date on which the hearing of the case was concluded, and due notice of the day so fixed shall be given to the parties or their pleaders. So maximum time limit for pronouncing the judgment after hearing of the case is 60 days. Rule 1, 2 of Order 20 says where a written judgment is to be pronounced, it shall be sufficient if the findings of the court on each issue and final orders passed in the case are read out, and it shall not be necessary for the court to read out whole judgment. When judgment may be altered or modified. Order 20 Rule 3 of CPC provides, the judgment shall be dated and signed by the in open court at the time of pronouncing it, and when once signed, shall not afterwards be altered or added, save a. To correct clerical or arithmetical mistakes or error due to accidental slips or omission, Section 152 CPC. B. On review, Section 114 CPC. So any alteration or addition in judgment is permissible so long as it is not signed by the judge in open court. Once it is signed, no alteration or addition can be done except to correct clerical or arithmetical mistakes or accidental slips as contemplated under Section 152 of Code or upon review. Recently in Jaya Lakshmi Coelho v. Oswald Joseph Coelho, AIR 2001 SC 1084 Supreme Court observed, in terms of Section 152 CPC, any error occurred in the decree on account of arithmetical or clerical error or accidental slip may be rectified by court, in a matter where it is clear that something which court intended to do but the same was accidentally slipped, or any mistake creeps in due to clerical or arithmetical mistake, it would only advance the end of justice to enable to rectify such mistake. But before exercise of such power, the court must be legally satisfied. That court must have in its mind that decree or order should be passed in particular manner, but that intention is not translated into the decree or order due to clerical, arithmetical error or accidental slip. Contents of Judgment Order. Rule 4 of the Code of Civil Procedure deals with the contents of the judgment also. Subrule 2 of Rule 4 of Order 20 of the Code of Civil Procedure provides that judgments of courts, other than small cause court, shall contain a. A concise statement of the case. B. The points for determination. C. The decision thereon, and D. The reasons for the decision. Subrule 1 of Rule 4 of Order 20 of the Code of Civil Procedure also provides that judgments of a court of small causes shall not contain more than the points for determination and the decision thereon. Rule 5 of the said order also provides that in suits in which issues have been framed, the court shall state its finding or decision with the reasons therefor, upon each separate issue, unless the finding, upon any one or more of the issues, is sufficient for the decision of the suit. Rule 5- of the said order, which has been inserted by Amendment Act No. 104 of 1976, also lays down that except where both the parties are represented by pleaders, the court shall, when it pronounces its judgment in a case subject to appeal, inform the parties present in court as to the court to which an appeal lies and the period of limitation for the filling of such appeal, and place on record the information so given to the parties. Rule 6-A 1. of the said order also lays down that the last paragraph of the judgment shall state in precise terms the relief which has been granted by such judgment. Q. 55. What are the provisions of Code of Civil Procedure relating to cost? Ans. Question of imposing costs in civil proceeding is entirely on the discretion of the court. Rules as to costs is subject to provisions of Code of Civil Procedure. Kinds of costs. The Code of Civil Procedure provides for 4 kinds of costs. 1. General costs, Section 35. 2. Miscellaneous costs, Order 20-A. 3. Compensatory costs for false or vexatious claims or defenses, Section 35-A, and 4. Costs for causing delay, Section 35B. 1. General costs, Section 35. A. Object. Section 35 deals with general costs. The object in awarding costs to a litigant is to secure to him the expenses incurred by him in the litigation. It neither enables the successful party to make any profit out of it nor punishes the opposite party. B. Principles. The primary rules in respect of award of general costs are as under. I. Costs are in the discretion of the court. The said discretion, however, must be exercised on sound legal principles. 2. Normally, costs should follow the event and the successful party is entitled to costs unless there are good grounds for depriving him of that right. Even a successful party may be deprived of the costs if he is guilty of misconduct or there are other reasons to do so. Subsection 2 of Section 34, however, expressly provides that when the court orders that costs should not follow the event, it must record reasons for doing so. 2. Miscellaneous costs, Order 20-A. Order 20-A makes specific provision with regard to the power of the court to award costs in respect of certain expenses incurred in giving notices, typing charges, inspection of records, producing witnesses and obtaining copies. 3. Compensatory costs, Section 35A. A. Object. Section 35-A provides for compensatory costs. This section is an exception to the general rule on which Section 35 is based, was that the costs are only an indemnity, and never more than indemnity. This section is intended to deal with those cases in which Section 35 does not afford sufficient compensation in the opinion of the court. Under this provision, if the court is satisfied that the litigation was inspired by vexatious motive and altogether groundless, it can take deterrent action. This section applies only to suits and not to appeals or to revisions. B. Conditions. The following conditions must exist before this section can be applied. 1. The claim or defense must be false or vexatious. 2. Objections must have been taken by the other party that the claim or defense was false or vexatious to the knowledge of the party raising it, and 3. Such claim must have been disallowed or withdrawn or abandoned in whole or in part. The maximum amount that can be awarded by the court is 3,000 rupees. 4. Costs of causing delay, Section 35B. Section 35-B is added by the Amendment Act of 1976. It is inserted to put check upon the delaying tactics of the litigating parties. It empowers the court to impose compensatory costs on the parties who are responsible for causing delay at any stage of the litigation. Such costs would be irrespective of the ultimate outcome of the litigation. The payment of costs has been a condition precedent for further prosecution of the suit, if the party concerned is a plaintiff and the defense, if he is a defendant. The provisions of this section are mandatory in nature and, therefore, the court should not allow prosecution of suit or defense, as the case may be, in the event of party failing to pay costs as directed by the court. If, however, the party is unable to pay costs due to unavoidable circumstances such as strike of advocates or staff, etc., court can extend the time. Q. 56. When do the execution proceeding begin and is the notice for execution necessary? If so, when? Ans. Execution. Term execution has not been defined in Code of Civil Procedure. However, expression execution means enforcement of decrees and orders by the process of the court, so as to enable the decree holder to realize the fruits of the decree. Section 38 of Code says a decree may be executed either by the court which passed it or by the court to which it is sent for execution. Section 37 defines the expression court which passed the decree. Section 37 has given widest possible definition of above said expression to facilitate the decree holder to realize the fruits of decree passed in his favor. As per Section 37, following courts fall within the expression court which passed the decree. I. Court of first instance by which decree is actually passed. 2. The court of first instance in the case of decree passed by appellate court. 3. Where the court of first instance has ceased to exist, the court which would have jurisdiction to try the suit at the time of execution. The execution proceedings can be started only after the delivery of judgment by the court and preparation of the decree. All proceedings in execution are started by an application for execution which can be oral or written, as the case may be. Rules 10 and 11 of Order 21 of the Code of Civil Procedure deal with the applications for execution. Rule 10 provides that where the holder of a decree desires to execute it, he shall apply to the court which passed the decree or to the officer, if any, appointed in this behalf, or if the decree has been sent under the provisions herein before contained to another court, then, to such court, or to the proper officer thereof. Rule 11, 1, of the said order deals with the oral application for execution, and it lays down that where a decree is for the payment of money, the court may, on the oral application of the decree holder at the time of the passing of the decree, order immediate execution thereof by the arrest of the judgment debtor, prior to the preparation of a warrant, if he is within the precincts of the court. Then Subrule 2 to Rule 11 of Order 21 of Code says that save as otherwise provided by Subrule 1, every application for the execution of a decree shall be in writing signed and verified by the applicant and shall contain particulars as provided in Subrule 2. Rules 11-A to 13 of Order 13 deal with certain specific applications for execution. Rule 11-A provides that where an application is made for arrest and detention of judgment debtor, it shall state, or be accompanied by an affidavit, stating the grounds on which arrest is applied for. Rule 12 deals with the application for attachment of movable properties not in possession of judgment debtor, which require decree holder to attach with application an inventory of property and their accurate descriptions. Rule 13 of Code then deals with application for attachment of immovable properties belonging to judgment debtor, and it also requires that application shall contain full description of property with boundaries, etc. For proper identification and also proof of judgment debtor's ownership or his share in it. Notice of execution. Notice is not to be issued to the party against whom execution application is filed in every case, but only in certain cases mentioned in Rule 22 of Order 21 of the Code of Civil Procedure. According to it, show cause notice is to be issued in the following cases. I. Where an application for execution is made more than 2 years after the date of decree. 2. Where an application for execution is made against the legal representative of a party to the decree, or where an application is made for execution of a decree filed under the provisions of Section 44- of the Code of Civil Procedure. 3. Where an application for execution is made against the assignee or receiver in insolvency where the party to the decree has been adjudged to be an insolvency. Show cause notice can also be issued by the court if the execution has been sought by arrest and detention of the judgment debtor in view of the provisions of Order 21 Rule 37 of the Code of Civil Procedure. Q. 57 Comment on the statement that an execution court cannot go behind the decree. Ans. Term execution has not been defined in CPC. Execution is enforcement of decree and order by process of the court, so as to enable the decree holder to realize the fruits of decree. Section 38 of CPC lays down that a decree may be executed either by the court which passed it or by court to which it is sent for execution. Section 37 defined the expression court which passed a decree and enlarged the scope of expression court which passed a decree so as to facilitate the decree holder to realize the fruits of decree passed in his favor. One of the most important rules regarding the execution is that it must take the decree as it stands and execute according to its terms. It has no power to vary or modify the terms. It has no power to question its legality or correctness. No inquiry into its regularity or correctness can be permitted in such a proceeding. Section 47 of CPC is important provision in this regard which lays down as to which questions are to be determined by court executing the decree. It provides 1. All questions arising between the parties to the suit in which the decree was passed or their representatives and relating to execution, discharge or satisfaction of decree shall be determined by court executing the decree, not by a separate suit. 2. Asterisk, 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 asterisk. 3. Where a question arises as to whether any person is or is not representative of a party, such question shall, for the purpose of this section, be determined by the court. Explanation I. For the purposes of this section, a plaintiff whose suit has been dismissed and a defendant against whom a suit has been dismissed are parties to the suit. Explanation 2. A. For the purposes of this section, a purchaser of property at a sale in execution of a decree shall be deemed to be a party to the suit in which the decree is passed, and Explanation 2. B. All questions relating to the delivery of possession of such property to such purchaser or his representative shall be deemed to be questions relating to the execution, discharge or satisfaction of the decree within the meaning of this section. The underlying object of this provision is to provide cheap and expeditious remedy for determination of certain questions in execution proceedings without recourse to a separate suit and to prevent needless and unnecessary litigation. So the executing court can go into all question between the parties relating to execution, discharge or satisfaction of decree, and as such court has no power to amend, modify or substitute a decree, or in other words cannot go behind the decree. Although an executing court cannot go behind the decree nor can it question its legality or correctness. But there is one exception to this general rule, and that is that where the decree sought to be executed is nullity for the lack of inherent jurisdiction in court passing it, its invalidity can be set up in an execution proceeding. The executing court can therefore entertain an objection that the decree is nullity and can refuse to execute the decree. In Kiran Singh v. Chaman Paswan, AIR 1954 SC 340, it was observed, it is a fundamental principle well established that a decree passed by a court without jurisdiction is a nullity, and that its invalidity could be set up whenever and wherever it is sought to be enforced or relied upon, even at the stage of execution and even in collateral proceedings. Q. 58. What is the effect of a decree passed in favor of a dead person? Ans. Decree passed in favor of a dead person. Where the court proceeds with the case in ignorance of the fact of death of a person and passes a decree, that decree cannot be treated as a nullity. It may, no doubt, be a wrong decree, but it will have to be set aside by taking appropriate proceedings like appeal, revision or review. Generally speaking, a decree passed in favor of a dead person is not a nullity, though a decree passed against a dead person can be construed as a nullity. Even if there is abatement of the suit, that would not make the decree passed in the suit as one without jurisdiction, and the executing court is not entitled to refuse to execute the decree on the ground that the plaintiff was not alive on the date when the decree was passed in his favor. Q. 59A is survived by his widow, daughter, sister and 4 brothers. On a partition suit filed by B, one of the brothers of deceased A, the disputed property fell to the share of C, the daughter of A. During the pendency of partition suit filed by B, B was appointed receiver of entire estate of A. In this capacity B inducted D as a tenant and took some advance from D, but the possession of whole of leased premises was not given to D. So D filed suit against B for recovery of amount of advance. This suit was decreed against B and his estate. In execution of this decree, D purchased the suit land belonging to C in auction and then transferred it to some other persons without any notice to B. C filed suit for recovery of possession of her land. Suit was resisted by D and is transferee on the ground inter alia that same is barred by Section 47 CPC. Decide whether the bar created by Section 47 CPC will apply to suit filed by C. Ans. Section 47 of the Code reads as under. 1. All questions arising between the parties to the suit in which the decree was passed, or their representatives, and relating to the execution, discharge or satisfaction of the decree, shall be determined by the court executing the decree and not by a separate suit. 2. Asterisk, asterisk, asterisk. 3. Where a question arises as to whether any person is or is not the representative of a party, such question shall, for the purposes of this section, be determined by the court. Explanation I. For the purposes of this section, a plaintiff whose suit has been dismissed and a defendant against whom a suit has been dismissed are parties to the suit. Explanation 2. A. For the purposes of this section, a purchaser of property at a sale in execution of a decree shall be deemed to be a party to the suit in which the decree is passed, and Explanation 2. B. All questions relating to the delivery of possession of such property to such purchaser or his representative shall be deemed to be questions relating to the execution, discharge or satisfaction of the decree within the meaning of this section. The underlying object of this provision is to provide cheap and expeditious remedy for determination of certain questions in execution proceedings without recourse to a separate suit and to prevent needless and unnecessary litigation. In order that this section may apply, the following conditions must be satisfied. I. The question must be one arising between the parties to the suit in which the decree is passed, or their representatives, and 2. It must relate to the execution, discharge or satisfaction of the decree. In the case in hand, during pendency of partition suit, B was appointed as receiver of estate of A, and in that capacity B inducted D as tenant to suit land which fell in the share of C. B had taken advance from D when D could not get the possession of leased property. D filed suit against B which was decreed against B and his estate and not against the estate of A. Therefore suit property which had fell in share of C, A's daughter, did not come in B's estate. In the execution of decree passed against B, share of C was not liable for satisfaction of said decree. It is also important that suit filed by D for recovery of advanced by him against B, C was not party in that suit. Therefore, none of the above said conditions apply for application of Section 47 CPC. Therefore, suit of C is not barred by Section 47. Q. 60. When can a decree holder apply to get the decree transferred to another court for execution? Ans. Transfer of the decree. Section 39 of the Code of Civil Procedure deals with the transfer of decree. It provides that the court which passed the decree may, on the application of the decree holder, send it for execution to another court of competent jurisdiction. A. If the person against whom the decree is passed actually and voluntarily resides or carries on business or personally works for gain within the local limits of the jurisdiction of such other court, or B. If such person has no property within the local limits of the jurisdiction of the court which passed the decree, sufficient to satisfy such decree, and has property within the local limits of the jurisdiction of such other court, or C. If the decree directs the sale or delivery of immovable property situate outside the local limits of the jurisdiction of the court which passed it, or D. If the court which passed the decree considers, for any other reason, which it shall record in writing, that the decree should be executed by such other court. The court which passed a decree may of its own motion send it for execution to any subordinate court of competent jurisdiction. For the purposes of this section, a court shall be deemed to be a court of competent jurisdiction if, at the time of making the application for the transfer of decree to it, such court would have jurisdiction to try the suit in which such decree was passed. Powers of the court to which a decree is transferred for execution. Section 42 of the Code of Civil Procedure deals with the powers of transferee court. It provides that the court executing a decree sent to it shall have the same powers in executing such decree as if it had been passed by itself. All persons disobeying or obstructing the decree shall be punishable by such court in the same manner as if it had passed the decree. Section 42(2) of Code says powers of transferee court shall include the following powers of the court which passed the decree, namely: A. Power to send decree for execution to another court under Section 39. B. Power to execute the decree against the legal representative of the deceased judgment debtor under Section 50. C. Power to order attachment of a decree. According to Section 42(4) of Code, transferee court cannot exercise the following power: A. Power to order execution at the instance of the transferee of the decree. B. In the case of decree passed against a firm, power to grant leave to execute such decree against any person other than such a person as is referred to in clause B or C of subrule 1 of Rule 50 of Order 21. Q. 61 discuss the provisions relating to arrest and detention in civil prison in execution of a decree. Ans. Arrest and detention in execution of a decree. One of the modes of executing decrees is arrest and detention in civil prison of the judgment debtor. Sections 55 to 59 and Rules 37 to 41 of Order 21 deal with arrest and detention of the judgment debtor in civil prison. Section 55 provides that a judgment debtor may be arrested in execution of a decree at any hour and on any day, and shall, as soon as practicable, be brought before the court, and his detention may be in the civil prison of the district in which the court ordering the detention is situate, or where such civil prison does not afford suitable accommodation in any other place which the state government may appoint for the detention of persons ordered by the courts of such district to be detained. Except that. Procedure. I. For the purposes of making an arrest under this section, no dwelling house shall be entered after sunset and before sunrise. 2. No outer door of a dwelling house shall be broken open unless such dwelling house is in the occupancy of the judgment debtor, and he refuses, or in any way prevents access thereto. But when the officer authorized to make the arrest has duly gained access to any dwelling house, he may break open the door of any room in which he has reason to believe the judgment debtor is to be found. 3. If the room is in the actual occupancy of a woman who is not the judgment debtor, and who, according to the customs of the country, does not appear in public, the officer authorized to make the arrest shall give notice to her that she is at liberty to withdraw, and, after allowing a reasonable time for her to withdraw and giving her reasonable facility for withdrawing, may enter the room for the purpose of making the arrest. 4. Where the decree in execution of which a judgment debtor is arrested, is a decree of the payment of money and the judgment debtor pays the amount of the decree and the costs of the arrest to the officer arresting him, such officer shall at once release him. Order 21 Rule 37 of the Code of Civil Procedure deals with the discretionary power of the court to issue show cause notice to the judgment debtor against detention in prison. It provides that where an application is for the execution of a decree for the payment of money by the arrest and detention in the civil prison of a judgment debtor who is liable to be arrested in pursuance of the application, the court shall, instead of issuing a warrant for his arrest, issue a notice calling upon him to appear before the court on a day to be specified in the notice and show cause why he should not be committed to the civil prison, provided that such notice shall not be necessary if the court is satisfied by affidavit, or otherwise, that with the object or effect of delaying the execution of the decree, the judgment debtor is likely to abscond or leave the local limits of the jurisdiction of the court. Subsection 2. Rule 37 lays down that where appearance is not made in obedience to the notice, the court shall, if the decree holder so requires, issue a warrant for the arrest of the judgment debtor. Subsection 3 of Section 55 of the Code of Civil Procedure also lays down that where a judgment debtor is arrested in execution of a decree for the payment of money and brought before the court shall inform him that he may apply to be declared an insolvent, and that he may be discharged if he has not committed any act of bad faith regarding the subject of the application, and if he complies with the provisions of the law of insolvency for the time being in force. Section 56 of the Code of Civil Procedure provides that a woman shall not be arrested in execution of decree in payment of money. Section 57 of the Code of Civil Procedure deals with the subsistence allowance payable by the decree holder for the subsistence of the judgment debtor. According to it, the state government may fix scales graduated according to rank, race and nationality of such monthly allowance. Period of detention. Section 58 of the Code of Civil Procedure deals with the period of detention. According to it, every person detained in the civil prison in execution of a decree shall be so detained. A. Where the decree is for the payment of a sum of money exceeding 1,000 rupees for a period not exceeding 3 months, and B. Where the decree is for the payment of a sum of money exceeding 500 rupees but not exceeding 1,000 rupees for a period not exceeding 6 weeks. How released? Provided that he shall be released from such detention before the expiration of the said period of detention. I. On the amount mentioned in the warrant for his detention being paid to the officer in charge of the civil prison, or 2. On the decree against him being otherwise fully satisfied, or 3. On the request of person on whose application he has been so detained, or 4. On omission to pay subsistence allowance by person on whose application he was so detained. Provided also that he shall not be released from such detention under clause 2 or 3 without the order of the court. Q. 62. What is a garnishee order and how is it enforced? Ans. Garnishee is a person who is liable either to pay debt to a judgment debtor or account for any movable property not in the possession of the judgment debtor. The garnishee order is an order issued to such a person not to pay back to the judgment debtor but to the court. The debt must be one other than a debt secured by a mortgage, a charge, a negotiable instrument, or a debt recovered only in a revenue court. A garnishee order is an order which a court is authorized to make against a garnishee judgment debtor requiring him to pay or deliver in court the amount due from or the property deliverable by him to the judgment debtor or so much as may be sufficient to satisfy the decree and the cost of execution. The court may, in the case of debt, other than a debt secured by a mortgage or a charge, which has been attached under Rule 46, attachment of a debt, share and other property not in possession of the judgment debtor, upon the application of the attaching creditor, issue notice to the garnishee liable to pay such debt, calling upon him either to pay into court the debt due from him to the judgment debtor or so much thereof as may be sufficient to satisfy the decree and costs of execution, or 2. Appear and show cause why he should not do so. Where the garnishee pays in the court the amount due from him to the judgment debtor or so much thereof as is sufficient to satisfy the decree and the costs of the execution, the court may direct that the amount may be paid to the decree holder towards satisfaction of the decree and costs of the execution. Order 21, Rule 46-A. Where the garnishee does not forthwith pay into court the amount due from him to the judgment debtor or so much thereof as is sufficient to satisfy the decree and the costs of execution, and does not appear and show cause in answer to the notice, the court may order the garnishee to comply with the terms of such notice, and on such order, execution may issue as though such order were a decree against him. Order 21, Rule 46-B. Where the garnishee disputes liability, the court may order that any issue or question necessary for the determination of liability shall be tried as if it were an issue in a suit, and upon the determination of such issue shall make such order or orders as it deems fit. Order 21, Rule 46-C. Q. 63. Explain the law relating to attachment of salary or allowances of servant of government or railway company or local authority. Ans. Attachment of salary of public officer, etc. According to Order 21, Rule 48, the court can order that the amount which not liable to attachment and sale in execution of a decree as per Section 60 of CPC be withheld from such salary or allowances either in one payment or by monthly installments. The officer or the person whose duty is to disburse shall then withhold and remit to the court the amount due under the order or the monthly installment, as the case may be. Section 60, Order 21 and Rule 48. Attachment of salary of private employees. Order 21, Rule 48- of the Code of CPC provides that where et property to be attached is the salary or allowances of an employee to whom Rule 48 applies, is within the local limits of the court's jurisdiction, may order that the amount shall, subject to the provisions of Section 60, be withheld from such salary or allowances either in one payment or by monthly installments as the court may direct, and upon notice of the order to such disbursing officer, such disbursing officer shall remit to the court the amount due under the order, or the monthly installments, as the case may be. Q. 64. What remedy is available to a person whose land has been wrongfully attached in the execution of a decree? Ans. Order 21 Rule 58 provides that where any claim is preferred to, or any objection is made to the attachment of, any property attached in execution of a decree on the ground that such property is not liable to attachment, the court shall proceed to adjudicate upon the claim or objection in accordance with the provisions herein contained, provided that no such claim or objection shall be entertained. A. Where, before the claim is preferred or objection is made, the property attached has already been sold, or B. Where the court considers that the claim or objection was designedly or unnecessarily delayed. Order 21, Rule 58, 1. All questions, including questions relating to right, title or interest in the property attached, arising between the parties to a proceeding or their representatives under Rule 58 and relevant to the adjudication of the claim or objection, shall be determined by the court dealing with the claim or objection and not by a separate suit. Order 21, Rule 58, 2. Upon the determination of the questions referred to in Subrule 2, the court shall, in accordance with such determination, A. Allow the claim or objection and release the property from attachment either wholly or to such extent as it thinks fit, or B. Disallow the claim or objection, or C. Continue the attachment subject to any mortgage, charge or other interest in favor of any person, or D. Pass such order as in the circumstances of the case it deems fit. Order 21, Rule 58, 3. Where a claim or an objection is preferred and the court, under the proviso to Subrule 1, refuses to entertain it, the party against whom such order is made may institute a suit to establish the right which he claims to the property in dispute, but, subject to the result of such suit, if any, an order so refusing to entertain the claim or objection shall be conclusive. Order 21, Rule 58, 5. In Canara Bank v. Gurmukh Singh AIR 2000 Dale 48, it was observed. After the introduction of Amendment Act in 1976, Order 21 contemplates an adjudicating. It is now necessary that objection filed under Order 21 Rule 58 should not be disposed of summarily. Wherever objections are filed under these provisions, these must be heard and disposed of by a procedure akin to that which obtains the disposal of a suit. It is open to a party to adduce evidence to prove his claim, and there is nothing in the section to make the court to adopt summary procedure when dealing with an application under Order 21 Rule 58. Subsection 4 to Rule 58 makes it clear that order under this provision shall have stause of decree. The object of the rule is to secure a speedy settlement of the question of title raised at an execution sale. It gives the claimant a speedy and summary remedy. The court is bound to decide the question of possession when an objection is made to attachment of the property in execution of a decree. On the question of possession, the onus is on the claimant or objector. Q. 65. When does a suit stand abated? What do you understand by complete and partial abatement? Ans. Abatement implies a suspension or termination of proceeding for want of proper parties. Provisions of Order 22 of Code of Civil Procedure deals with creation, assignment or devolution of interest during pendency of suit as well as appeal, but not execution proceedings due to death, marriage or insolvency of parties. Rule 1 of Order 22 CPC provides that the death of plaintiff or defendant shall not cause the suit to abate if the right to sue survives. In Krishna Singh v. Mathura Ahir AIR 1980 SC 707, it was observed. When a party to a suit dies, the first question to be decided is whether the right to sue survives or not. If it does not, there is an end of the suit. If it does, the suit will not abate. The expression right to sue may be interpreted to mean right to seek relief. General rule is that all rights of action and all demands whatsoever existing in favor of or against a person at the time of his death survive to or against his representatives. Rules 1 to 6 of Order 22 provide as to consequences in case of death of party to suit. Rule 2 says, where there are more plaintiffs or defendants than one and any of them dies, and where the right to sue survives to the surviving plaintiff or plaintiffs alone or against the surviving defendant or defendants alone, the court shall cause an entry to that effect to be made on record, and suit shall proceed at the instance of surviving plaintiffs or against surviving defendants, as the case may be. Rule 3 says where one of two or more plaintiffs dies, and the right to sue does not survive to surviving plaintiff or plaintiffs alone, or a sole plaintiff or sole surviving plaintiff dies, and right to sue survive, the court on an application made in that behalf shall cause the legal representative of the deceased plaintiff to be made a party, and shall proceed with the suit. Where within the time limited by law, i.e. within 90 days of death, no application is made, the suit shall abate so far as the deceased plaintiff is concerned. Rule 4 then lays down that where one of two or more defendant dies, and right to sue does not survive against the surviving defendant or defendants alone, or where sole defendant or sole surviving defendant dies, and right to sue survives, the court on an application made in that behalf shall cause the legal representatives of deceased defendant to be made party, and proceed with the suit. However, where within the time limited by law, i.e. 90 days of death, no application is made, the suit shall abate against the deceased defendant. Rule 4 of Order 22, however, provide that court, whenever it think fits, exempt the plaintiff from the necessity of substituting the legal representatives of any such defendant who has failed to file written statement, or who, having filed it, has failed to appear and contest the suit at the hearing, and the judgment may in such case be pronounced against said defendant notwithstanding the death of such defendant, and shall have same effect and force as if it has been pronounced before his death. Rule 4.5 says where the plaintiff was ignorant of death of defendant and could not for that reason make an application for substitution of legal representative of such defendant within the prescribed period and the suit is abated, plaintiff may make an application for setting aside such abatement, and in considering the said application the court shall have due regard to the fact of such ignorance of plaintiff. In Dhurandhar Prasad v. Jayaprakash University and other, AIR 2001 SC 2552, it was observed by Supreme Court that Order 22 Rules 3 and 4 prescribe procedure in case of devolution of interest on death of party to suit. It says if party dies and right to sue survives, court on application made in this behalf is required to substitute legal representatives of deceased party, but if such application is not filled within time prescribed, suit shall abate so far as deceased party is concerned, whereas Rule 10 of Order 22 CPC provides for cases of assignment, creation and devolution of interest, other than those referred to in foregoing rules. In cases covered under Rules 384, if right to sue survives, and no application for bringing legal representatives of deceased party filled within time prescribed, there is automatic abatement of suit. In cases covered under Rule 10, legislature has not prescribed any such procedure. Q. 66 Plaintiff came to know about death of defendant on 15 December 1994 from remarks of process server on summons received in court unserved that defendant died on 1 June 1994. He moved an application immediately for substitution of legal representative of deceased defendant. Would this application be allowed or rejected on the ground of expiry of period prescribed therefore? Ans. Rule 4 of Order 22 of the Code of Civil Procedure lays down the procedure in such cases. According to it, where one of two or more defendants die, and the right to sue does not survive against the surviving defendant or defendants alone, or a sole defendant or sole surviving defendant dies, and the right to sue survives, the court, on an application made in that behalf, shall cause the legal representative of the deceased defendant to be made a party, and shall proceed with the suit. Subrules 3 of Rule 4 of Order 22 CPC lays down that where within the time limited by law, which is 90 days, no application is made under Subrule 1, the suit shall abate as against the deceased defendant. However, Rule 4.5 provides that where the plaintiff was ignorant of the death of defendant and could not for that reason make an application for substitution of legal representative of deceased defendant within the prescribed period and suit is abated, plaintiff may make an application for setting aside such abatement, and in considering such application, court shall have due regard to the fact of such ignorance of the plaintiff. In case in hand, plaintiff was ignorant about death of defendant, and on coming to know about death of defendant from remarks of process server, he immediately move application for substitution of legal representatives of deceased defendant. So his application may be allowed in view of provisions contained in Rule 4.5 of Order 22 of Code. Q. 67. A. What is the doctrine of restitution? Has a court inherent power to grant restitution? B. A. Obtain the decree against. B. For possession be filed an appeal against the decree and obtain stay of delivery. The appeal was allowed and the suit dismissed. Against the dismissal a preferred second appeal, and that was allowed and decree of trial court was restored. A. Applied in restitution for masonry profits from the day of stay order of First Appellate Court to the date of the decree of Second Appellate Court. Is A. entitled to the masonry profits so claimed? C. A. Obtained the decree ex parte against B, and in the execution of the decree brought the properties of B to sale, and himself became the purchaser. On appeal by B, the appellate court set aside the decree and remanded the suit for rehearing. Then B applied for restitution. While that application was pending, the suit was heard and again decreed. A then contended that as the suit had been decreed, no restitution could be granted. Is B entitled to restitution? Ans. A. The expression restitution means restoring to a party the benefit which the other party has received under a decree subsequently held to be wrong. The principle of the doctrine of restitution is that on the reversal of a decree the law imposes an obligation on the party to suit who received an unjust benefit of erroneous decree to make restitution to the other party for what he has lost. Doctrine is based on maxim actus curia neminem gravabit, i. The act of court shall harm no one. Doctrine of restitution as embodied under Section 144 of Code, however, does not confer any new substantive right to party but is a rule of equity. In order that Section 144 of Code apply, following conditions must be satisfied. A. Restitution sought must be in respect of decree or order which has been reversed or varied. B. The party applying for restitution must be entitled to benefit under the reversing decree or order. C. The relief claimed must be properly consequential on the reversal or variation of decree or order. If these conditions are satisfied, the court must grant restitution. In Bhagwanti Singh v. Lala Shri Kishan Das, AIR 1953 SC 136, it was observed, the doctrine of restitution is that on reversal of a judgment the law raises an obligation on the party to the restorer who has received the benefit of the erroneous judgment to make restitution to the other party for what he had lost, and it is duty of court to enforce that obligation unless it is shown that restitution would be clearly contrary to real justice of case. Restitution under inherent power. In Kavita Rehan, Mrs. V. Balsala Hygiene Products Limited AIR 1995 SC 44, it was observed, the jurisdiction to make restitution is inherent in every court and will be exercised whenever the justice of case demands. It will be exercised under inherent power where the case did not strictly fall within the ambit of Section 144. Ans. B. The court is competent to make orders as to masonry profits consequent upon an order of restitution and cannot refer the party to a separate suit. Court has ample power under Section 144 CPC to make restitution to party which has been deprived of fruits of its decree by an order of court at the instance of judgment debtor. Even though a party may not claim masonry profits, the same may be granted by way of restitution if on account of action of court a party is deprived of benefit of decree. The facts of the case in hand have been borrowed from a judgment in Indiram Mansa Ram v. Ramdeen Bhagwant Prasad AIR 1961 MP 200. It was held, where a party is deprived of possession of property due to an order or decree of court below, which is later reversed or varied by appellate court, the court could under the power conferred by Section 144 place the party, who has been deprived of possession temporarily, in the position as if the reversed decree had not at all been passed. In view of above discussion, it can be held that A is entitled to masonry profit from date of stay order of first appellate court till the date of decree passed by second appellate court. Ans. C. The object of restitution is to restore the status quo ante between the parties. The principle of restitution is that on the reversal of a decree, the law imposes an obligation on the party to the suit who received the benefit of the erroneous decree to make restitution to the other party what he has lost. In Binayak Swain v. Ramesh Chandra, AIR 1966 SC 948, it was held, where in execution of an ex parte decree passed in appeal by the district judge, the property of the judgment debtor is sold and purchased by the decree holder himself, and the decree of the district judge is set aside by the High Court, and the suit is remanded for rehearing and fresh disposal. The judgment debtor is under Section 144 Civil PC entitled to restitution of his properties purchased by the decree holder subject to equities to be adjusted which was set aside by the High Court is not validated by the passing of the application for restitution. Judgment debtor was entitled to restitution because on that date the decree in execution of which the properties were sold had been set aside. He is entitled to restitution notwithstanding anything which happens subsequently, as the right to claim restitution is based upon the existence or otherwise of a decree in favor of the plaintiff at the time when the application for restitution was made. It was observed by Supreme Court. The principle of the doctrine of restitution is that on the reversal of a decree, the law imposes an obligation on the party to the suit who received the benefit of the erroneous decree to make restitution to the other party for what he has lost. This obligation arises automatically on the reversal or modification of the decree and necessarily carries with it the right to restitution of all that has been done under the erroneous decree, and the court in making restitution is bound to restore the parties, so far as they can be restored, to the same position they were in at the time when the court, by its erroneous action, had displaced them from. In view of the above discussion, the objection raised by A is not sustainable, and B is entitled to restitution of his property. Q. 68. A. Discuss the procedure to be adopted by court in a suit by or against government or public officer. B. A plaintiff gives notice under Section 80 of the Civil Procedure Code and institutes a suit before 2 months but is allowed to withdraw the same with liberty to file a fresh suit. Is he entitled to file a fresh suit without a fresh notice? C. Notice is given by A under Section 80 of the Civil Procedure Code of a proposed suit. A dies before the institution of the suit. Does the notice by A inure for the benefit of his legal representative? Ans. A. Order 27 Sections 79 to 82 of Civil Procedure Code deal with procedure in any suit brought by or against government or public officer. Notice. Section 80C.P.C provides for giving of notice prior to filing of suit against government or public officer. Section 80 says no suit shall be instituted against government or public officer in respect of any act purporting to be done by him in his official capacity until expiration of 2 months next after giving notice in writing has been delivered to government or to such public officer. In Bihari Chaudhary v. State of Bihar AIR 1981 SC 1043, Supreme Court observed that section has been enacted as a measure of public policy with the object of ensuring that before a suit against government of public officer is instituted in the court, the government or public officer concerned is afforded an opportunity to scrutinize the claim in respect of which the suit is proposed to be filed, and if it is found to be just claim, to take immediate action and avoid unnecessary litigation. Notice under Section 80 should contain A. Name, description and place of residence of plaintiff. B. A statement of cause of action. C. Statement of relief claimed. D. Any other important information. Subsection 2 to Section 80 provides that a suit may be instituted with the leave of court for obtaining urgent or immediate relief claimed against government of public officer in his official capacity without serving statutory notice. But in such case court shall not grant relief in the suit whether interim or otherwise except after giving to government of public officer, as the case may be, a reasonable opportunity of showing cause in respect of relief claimed. Order 27C.P.C provides regarding procedure to be followed in such suit. Ans. B. Section 80 of CPC provide regarding giving of notice prior to filing any suit against government or public servant. Section 80 says no suit shall be instituted against government or against a public officer in respect of any act purporting to be done by such public officer in his official capacity until the expiration of 2 months next after notice in writing has been delivered to government or to such public officer. In Bihari Chaudhary v. State of Bihar AIR 1984 SC 1043 explaining the underlying object behind Section 80, Supreme Court observed, Section has been enacted as a measure of public policy with the object of ensuring that before a suit is instituted against the government or a public officer, the government or officer concerned is afforded opportunity to scrutinize the claim in respect of which suit is proposed to be filed, and if it be found to be just claim, to take immediate action and thereby avoid unnecessary litigation. However, subsection 2 of Section 80 provides that a suit may be instituted with the leave of the court for obtaining an urgent or immediate relief against the government or any public officer in respect of any act purporting to be done by such public officer in his official capacity without serving a statutory notice. But in such a case, the court shall not grant relief in the suit, whether interim or otherwise, except after giving to the government or the public officer, as the case may be, a reasonable opportunity of showing cause in respect of the relief prayed for in the suit. In Amarnath Dogra v. Union of India AIR 1963 SC 424, a fresh notice under Section 80 CPC is not necessary where a suit is instituted, but that is withdrawn with liberty to file a fresh suit. If the plaint which is being considered by the court has been preceded by a notice which satisfies the requirements of Section 80 CPC, then the fact that before the plaint then under consideration, there had been another plaint which had been filed and withdrawn cannot, on any principle, be held to have exhausted or extinguished the validity of the notice issued. In view of the above discussion, a plaintiff can file a fresh suit without serving a fresh notice. Ans. See in Biohar Rajendra Singh v. State of MP 1970, 1, SCJ 118, it was observed, the object of the notice under Section 80 CPC is to give to the government or the public servant concerned an opportunity to reconsider its or his legal position, and if that course is justified, to make amends or settle the claim out of court. The section is no doubt imperative, failure to serve notice complying with the requirements of the statute. But the notice must be reasonably construed. Supreme Court, in various case laws, has adopted the rule of substantive compliance in dealing with requirement of giving notice under Section 80 CPC. A notice under Section 80 should be held sufficient if it substantially fulfills its object of informing the parties concerned of the nature of the suit to be filed. In Ghanshyam Das v. Dominion of India, 1984 AWC 407, SCAIR 1984 SC 1004, Supreme Court held, where a notice under Section 80 given by the plaintiff's father reached the concerned Department of the Dominion of India, and it was replied by not accepting the claim of the father of the plaintiff, but before instituting the suit the plaintiff's father died, the suit by the legal heirs of the deceased without giving fresh notice under Section 80 CPC is maintainable, and the notice by the deceased will endure for the benefit of his legal heirs. In view of above discussion, it is clear that no fresh notice under Section 80 of Code is required to be given by A's legal representative after A's death, when A had earlier given notice under Section 80 before filing suit. Q. 69. Who is minor under the Indian law? State the procedure to be adopted for a suit by or against a minor and persons of unsound mind. A compromise decree is passed in a suit involving interest of minor. Can the minor challenge such decree? If so, on what grounds? Ans. Minor. Section 3 of Indian Majority Act 1875 provides every person domiciled in India shall be deemed to have attained majority when he shall have completed his age of 18 years and not before. But if before the expiry of the age of 18, a guardian for the person or for the property or for both of the minor has been appointed or declared by a court, then the period of minority is extended till the completion of the age of 21 years. Order 32 of Civil Procedure Code prescribe the procedure of suits to which minor or persons of unsound mind are parties. Rule 1 of Order 32 of Code lays down that every suit by minor shall be instituted in his name by a person who in such suit shall be called the next friend of the minor. Rule 3 of Order 32 of the Code of Civil Procedure provides that where the defendant is a minor, the court, on being satisfied of the fact of his minority, shall appoint a proper person to be guardian for the suit for such minor. An order for the appointment of a guardian for the suit may be obtained upon application in the name and on behalf of the minor or by the plaintiff, and such applications shall be supported by an affidavit verifying the fact that the proposed guardian has no interest in the matters in controversy in the suit adverse to that of the minor, and that he is a fit person to be so appointed. No order shall be made on any application under this rule except upon notice to any guardian of the minor appointed or declared by an authority competent in that behalf, or where there is no such guardian upon notice to the father, or where there is no father, to the mother, or where there is no father or mother, to other natural guardian of the minor, or where there is no father, mother or other natural guardian, to the person in whose care the minor is, and after hearing any objection which may be urged on behalf of any person served with notice. Rule 4 of Order 32 of the Code of Civil Procedure provides who may act as next friend or be appointed guardian for the suit. According to it, any person who is of sound mind and has attained majority may act as next friend of a minor or as his guardian for the suit, provided that the interest of such person is not adverse to that of the minor, and that he is not, in the case of a next friend, a defendant, or in the case of a guardian for the suit, a plaintiff. Where a minor has a guardian appointed or declared by competent authority, no person other than such guardian shall act as the next friend of the minor or be appointed his guardian for the suit unless the court considers, for reasons to be recorded, that it is for the minor's welfare that another person be permitted to act or be appointed, as the case may be. No person shall without his consent in writing be appointed guardian for the suit. In Ashraf Lal v. SMT, Koili AIR 1995 SC 1440, Supreme Court has observed that in case of a decree against minor can file suit to set aside the decree if there is gross negligence on the part of his next friend. Effect of non-compliance of the provisions relating to minors. According to Rule 2 Order 32 of the Code of Civil Procedure, where a suit is instituted by or on behalf of a minor without a next friend, the defendant may apply to have the plaint taken off the file with costs to be paid by the pleader or other person by whom it was presented. Notice of such application shall be given to such person, and the court, after hearing his objection, if any, may make such order in the matter as it thinks fit. If a minor defendant is sued without a guardian ad litem, the decree in favor of the plaintiff is a nullity and inoperative, and it cannot be enforced against the minor. Agreement or compromise by next friend or guardian for the suit. Rule 7 of Order 32 of the Code of Civil Procedure deals with agreements or compromise on behalf of minors. It provides that no next friend or guardian for the suit shall, without the leave of the court, expressly recorded in the proceedings, enter into the agreement or compromise on behalf of a minor with reference to the suit in which he acts as next friend or guardian. Subrule 1-A of the said rule, which has been inserted by Amendment Act Number 104 of 1976, lays down that an application for obtaining the leave of the court shall be accompanied by an affidavit of the next friend or the guardian for the suit, as the case may be, and also, if the minor is represented by a pleader, by the certificate of the pleader, to the effect that the agreement or compromise proposed is, in his opinion, for the benefit of the minor. Provided that the opinion so expressed, whether in the affidavit or in the certificate, shall not preclude the court from examining whether the agreement or compromise proposed is for the benefit of the minor. Thus, according to the said provisions, it is the duty of the court to safeguard the interest of the minors, and any compromise which is not beneficial to the interest of the minor should not be allowed. In Kumari Manju Gupta v. National Insurance Co. 1993 HVD Volume 4 page 357, it was held that in a claim petition on behalf of a minor, no settlement can be arrived at without leave of the court, as required under Rule 7 of Order 30 to CPC. Provisions contained in Rules 6 and 7 of said order are mandatory and adil. District judge could not legally act upon that settlement without applying its mind to see whether amount agreed between parties is adequate to compensate the minor girl. In Sant Bhushan Lal v. Brij Bhushan Lal, AIR 1967 Dale 137, it was held that where a next friend or guardian ad litem of minor enters into a compromise on his behalf with permission of the court under Order 32-7, the compromise and decree based thereon would be as much binding on the minor as it is on adult parties, unless the minor can show that the next friend or his guardian ad litem was guilty of fraud or negligence. So minor can challenge a compromise decree passed against him on the grounds, I. That the compromise has been effected without the leave of the court, 2. That the next friend or guardian ad litem has been guilty of gross negligence, and 3. That there has been fraud or collusion on the part of next friend or guardian ad litem. Q. 70 discuss the validity of the following. A. Decree against a major treating him as a minor. B. Decree against a minor treating him as a major. C. Decree in favor of a minor without a next friend. D. Decree passed against a minor in a suit in which he is not represented by a guardian ad litem. E. Decree passed against a person who is a minor at the date of the institution of the suit with a properly appointed guardian ad litem. He attains majority during the pendency of the suit, but no steps are taken to remove the guardian ad litem and the decree is passed against him as a minor. Ans. A. A decree obtained against a major treating him as a minor at the date is not a nullity, but is only an irregularity, which is curable. B. Decree against a minor treating him as a major is a nullity. C. It is only an irregularity which is deemed to be waived by the defendant if he does apply to have the plaint taken off the file under Order 32, Rule 2. The decree is consequently valid. Moreover, the law treats all acts of a minor which are for his benefit on the same footing as those of an adult. It only does not permit him to do anything which is prejudicial to his own interests. D. A decree passed against a minor in a suit in which he is not represented by a guardian ad litem is a nullity and cannot be enforced against him. E. The decree passed in the suit is a valid decree. The question under consideration is governed by Rule 3(5) of Order 23, which provides that a person appointed to be guardian ad litem for a minor shall, unless his appointment is terminated by retirement, removal or death, continue as such throughout all proceedings arising out of the suit, including the proceedings in any appellate or revisional court and any proceedings in the execution of a decree. Consequently, the guardian ad litem does not automatically cease to function on the minor's attaining majority. It is necessary for the minor on attaining majority that he should take steps to have his guardian removed, and in the absence of such steps, he will continue to function as guardian, and the decree passed against the defendant as minor in the suit will be a valid decree. Q. 71 discuss the validity of the following. I. Decree against a person of unsound mind supposing him to be of sound mind. 2. Decree passed against a minor in a suit in which he is not represented by a guardian ad litem. 3. A person who was minor at the date of the institution of suit with the proper guardian ad litem attains majority during the pendency of suit, but no steps are taken to remove the guardian ad litem and a decree is passed against him as a minor. Ans. I. And 2. Rule 15 of Order 32 CPC has provided that all the rules except Rule 2- of Order 32 equally extend to persons adjudged to be of unsound mind or who, though not so adjudged, are on inquiry found by the court, by reason of mental infirmity incapable of protecting their interests when suing or being sued. Therefore, as Rule 3 Order 30 to say that where the defendant of suit is minor or person of unsound mind, then court on being satisfied of fact of minority or insanity of defendant, shall appoint a proper person as guardian ad litem of such minor or person of unsound mind. These provisions are mandatory. Therefore, when decree is passed against person of unsound mind or against minor without complying with provisions of Rule 3 Order 32 CPC, i.e. without appointment of guardian ad litem, such decree is a nullity and cannot be enforced against him. In Rama Lal v. Lakshmi, AIR 1940 Ajmer 48, it was held that lunatics are under the special protection of the court, and decree will not be effective even if by ignorance of court, no inquiry as to mental infirmity of the defendant was made. Ans. 3. No provision has been made in the code in respect of a minor defendant attaining majority during the pendency of the suit. The reason for the omission is that while a plaintiff minor on becoming major can elect either to go on with or put an end to the litigation, but the defendant has no such choice available to him and suit must proceed against him notwithstanding his becoming major. A decree passed against a person who was a minor at the date of the institution of the suit with a properly appointed guardian ad litem but attains majority during the pendency of the suit without any steps being taken to remove such guardian, with the result that the decree is passed against him as a minor, is a valid decree, as the guardian ad litem does not automatically cease to function on the minor attaining majority, but continues to represent him throughout all proceedings unless his appointment is terminated by retirement, removal or death under Rule 3(5) of Order 32. Q. 72. Who is an indigent person? What is the mode of instituting suits by such person? Ans. Object. Order 33 CPC deals with suits by indigent persons. Provisions of Order 33 are intended to enable the indigent person to institute suits without payment of court fees. Generally, a plaintiff suing in a court of law is bound to pay court fee. Indigent person meaning. Explanation 1 to Rule 1 says a person is an indigent person if I. He is not possessed of sufficient means to enable him to pay the fee prescribed by law for the plain in such suit, or 2. Where no such fee is prescribed, when he is not entitled to property worth 1,000 rupees. In both the cases, the property exempt from attachment in execution of a decree and the subject matter of the suit should be excluded. Application. Rule 2. Every application for permission to sue as an indigent person should contain following particulars. 1. Particulars required in regard to plaints in suits. 2. Schedule of movable or immovable property belonging to applicant with estimated value thereof. 3. Signature and verification as provided in Order 6 Rules 14 and 15 CPC. The application is to be presented to the court by applicant in person unless appearance is exempted. Rule 1 of Order 33 provides for initial enquiry into the means of applicant by officer of court. Rule 4 provides that where application is in proper form and duly presented, court may if it think fit examine the applicant and his agent regarding the merits of the claim and property of applicant. Rule 5 provides that the court may reject an application for permission to sue as an indigent person on the following grounds. I. Where it is not framed and presented in the manner prescribed above. 2. Where the applicant is not an indigent person. 3. Where he has within 2 months next before the presentation of the application disposed of any property fraudulently or in order to be able to apply for permission to sue as an indigent person. Provided that no application shall be rejected if even after the value of the property disposed of by the applicant is taken into account, the applicant would be entitled to sue as an indigent person. 4. Where his allegations do not show a cause of action. Where he has entered into any agreement with reference to the subject matter of the proposed suit under which any other person has obtained an interest in such subject matter. 6. Where the allegations made by the applicant in the application show that the suit would be barred by any law for time being in force. 7. When any other person has entered into an agreement with him to finance the litigation. Rule 6 of Order 33 then says, where the application is not rejected, the court shall fix a date for receiving evidence in proof or disproof of applicant's indigency. Rule 7 says that on the day so fixed the court shall examine the witnesses, if any, produced by either side, and it shall also hear the arguments of parties, and then either allow or refuse to allow the applicant to sue as an indigent person. Rule 8 says where the application is granted, it shall be numbered and registered and shall be deemed to be a plaint in the suit, and the suit shall proceed in ordinary manner, except that the plaintiff shall not be liable to pay any court fees or process fees. Where the court rejects the application to sue as an indigent person, order of refusal bars a subsequent similar application, but the applicant may sue in the ordinary manner provided he pays the costs incurred by the government or opposite party in opposing such application. Q. 73. Under what circumstances can a court order arrest before judgment? Ans. Order 38 Rules 1 to 4 of the Code of Civil Procedure deal with arrest before judgment. Rule 1 of Order 38 of the Code of Civil Procedure provides that where at any stage of a suit, other than a suit of the nature of referred to in Section 16, clauses A to D, the court is satisfied by affidavit or otherwise. A. That the defendant, with intent to delay the plaintiff or to avoid any process of the court, or to obstruct or delay the execution of any decree that may be passed against him. I. Has absconded or left the local limits of the jurisdiction of the court, or 2. Is about to abscond or leave the local limits of the jurisdiction of the court, or 3. Has disposed of or removed from the local limits of the jurisdiction of the court his property or any part thereof, or B. That the defendant is about to leave India under circumstances affording reasonable probability that the plaintiff will or may thereby be obstructed or delayed in the execution of any decree that may be passed against the defendant in the suit. The court may issue a warrant to arrest the defendant and bring him before the court to show cause why he should not furnish security for his appearance. Provided that the defendant shall not be arrested if he pays to the officer entrusted with the execution of the warrant any sum specified in the warrant as sufficient to satisfy the plaintiff's claim, and such sum shall be held in deposit by the court until the suit is disposed of or until further order of the court. Where the defendant fails to show such cause, the court shall order him either to deposit in court money or other property sufficient to answer the claim against him, or to furnish security for his appearance at any time when called upon while the suit is pending, and until satisfaction of any decree that may be passed against him in the suit, or make such order as it thinks fit in regard to the sum which may have been paid by the defendant under the proviso to the last preceding rule. Order Rule to CPC. Rules 3 and 4 of Order 38 of the Code of Civil Procedure deal with the procedure where the surety applies for being discharged and the defendants fail to furnish security or find fresh surety. Sub-Rule 3 lays down that a surety for the appearance of a defendant may at any time apply to the court in which he became such surety to be discharged from the obligation, and on such application being made, the court shall summon the defendant to appear or, if it thinks fit, may issue a warrant for his arrest in the first instance. On the appearance of the defendant in pursuance of the summons or warrant or, on his voluntary surrender, the court shall direct the surety to be discharged from his obligation, and shall call upon the defendant to find fresh security. Q. 74. Under what circumstances may a court order attachment before judgment? Ans. Attachment before judgment according to Rule 5 of Order 38, where, at any stage of a suit the court is satisfied, by affidavit or otherwise, that the defendant with intent to obstruct or delay the execution of any decree that may be passed against him, A. is about to dispose of the whole or party of his property, or B. is about to remove the whole or any part of his property from the local limits of the jurisdiction of the court. The court may direct the defendant either to furnish security in such sum as may be specified in the order, to produce and place at the disposal of the court, when required, the said property of the value of the same or such portion thereof as may be sufficient to satisfy the decree, or to appear and show cause why he should not furnish security. Order 38, Rule 5, 1. The plaintiff shall, unless the court otherwise direct, specify the property required to be attached and the estimated value thereof. Order 38, Rule 5, 2. The court can also order conditional attachment of whole or part of the property. Q. 75. What do you understand by temporary injunction? What is its scope? When can the court grant temporary injunction? Ans. Temporary injunction. Temporary injunction is an order by which a party to suit is required to do or to refrain from doing a particular act until the suit is disposed or until further order of the court. It is in the nature of an interim order passed by the court. Order 39 of Code of Civil Procedure deals with temporary injunction. Rules 1 and 2 of Order 39 of Code of Civil Procedure are relevant, which read as under. Rule 1. Cases in which temporary injunction may be granted where in any suit it is proved by affidavit or otherwise. A. That any property in dispute in a suit is in danger of being wasted, damaged or alienated by any party to the suit, or wrongfully sold in execution of a decree, or B. That the defendant threatens or intends to remove or dispose of his property with a view to defrauding his creditors. C. That the defendant threatens to dispose the plaintiff or otherwise cause injury to him in relation to disputed property. The court may by order grant a temporary injunction to restrain such act until the disposal of the suit or until further orders. Rule 2. Injunction to restrain repetition or continuance of breach in any suit for restraining the defendant from committing a breach of contract or other injury of any kind, whether compensation is claimed in the suit or not, the plaintiff may, at any time after the commencement of the suit, and either before or after judgment, apply to the court for a temporary injunction to restrain the defendant from committing the breach of contract or injury complained of, or any breach of contract or injury of a like kind arising out of the same contract or relating to the same property or right. Scope. The power to grant temporary injunction is discretionary, and the discretion has to be exercised judicially. The grant of temporary injunction pending the suit of permanent injunction is a very serious matter, as it affects the rights of the person in possession of property and restricts him from using the same at his disposal just because a suit has been instituted in this respect. It is thus too serious a matter to be given a casual or routine treatment. It may be noted that application of temporary injunction is instituted only where regular suit for permanent injunction is pending before the same court with whom the application for temporary injunction has been instituted. Temporary injunction cannot be granted unless it appears that there are chances of success of the basic suit of permanent injunction. Where a permanent injunction cannot be given, generally no temporary injunction is allowed. Thus, grant of an ad interim injunction is an extraordinary thing. Guiding principles. Before granting of the temporary injunction, the following conditions are required to be satisfied, namely: I. Prima facie the case is in favor of the plaintiff and against the defendant. 2. Irreparable injury is likely to be caused to the plaintiff which cannot be compensated for in terms of money. 3. Balance of convenience lies in favor of the plaintiff and against the defendant. Q. 76 A constructed a house for B under an agreement. B revoked the agreement complaining that the work was incomplete, shoddy and grossly delayed. A file suit for wrongful termination of contract and for recovery of 50 rupees lakhs allegedly outstanding for the work done. B also filed suit for recovery of 12 rupees lakhs allegedly overpaid and for permanent injunction. He filed an application for grant of ad interim injunction under O. 39, Rules 1 and to CPC for restraining A from entering upon it. A resisting it contended that the construction is complete and it was wrongful on the part of B to revoke the agreement, that a huge sum is outstanding for the work done and he has a lien over the building, his license cannot be revoked till his dues are paid, and that grant of temporary injunction will amount to decreeing the suit itself. Decide BS ad interim injunction application. Ans. Temporary injunction is an order by which a party to an action is required to do or refrain from doing a particular thing until the suit is disposed of or until further orders of court. Temporary injunction is interim in nature, granted on an interlocutory application of plaintiff. The granting of temporary injunction is a matter of discretion of court, to be exercised judicially according well-settled principles. Rule 1 of Order 39 of Code provide that where in any suit it is proved by affidavit or otherwise. A. Property in dispute in a suit is in danger of being wasted, damaged or alienated by any party to suit or wrongfully sold in execution of a decree. B. Defendant threatens or intends to remove or dispose of his property with a view to defrauding his creditors. C. Defendant threatens to dispose the plaintiff or otherwise cause injuries to plaintiff in relation to property in dispute in suit. Court may by order grant a temporary injunction to restrain such act or to make such order for the purpose of staying or preventing the wasting, damaging, alienation, sale or removal, etc., or dispossession of plaintiff or otherwise causing injury to plaintiff in relation to property in dispute, as court think fit until the disposal of suit or further orders. In Dorab Kavas GV, Kumi Sora, AIR 1990 SC 867, it was observed, object of making an order regarding interim relief is to evolve a workable formula to the extent called for by demands of situation, keeping in mind the pros and cons of matter and striking a delicate balance between two conflicting interests, i.e. injuries and prejudice likely to be caused to plaintiff if relief is refused, and injury and prejudice likely to be caused to defendant if the relief is granted. Underlying object of granting temporary injunction is to maintain and preserve status quo at the time of institution of proceedings and to prevent any change in it until the final determination of suit. It was also observed the power to grant a temporary injunction is in discretion of court, and before granting the injunction the court must be satisfied about following aspects. First, applicant must make out a prima facie case in support of right claimed by him. Court must be satisfied that there is a bona fide dispute raised by applicant and there is probability of the applicant being entitled to relief claimed by him. So, existence of prima facie right and infraction of such right is condition precedent to grant a temporary injunction. 2. It is necessary to prevent irreparable or serious injury which normally cannot be compensated in terms of money. 3. The balance of convenience is in favor of one seeking such relief. Being essentially an equitable relief, the grant or refusal of temporary injunction shall ultimately vest in the sound judicial discretion of the court to be exercised in the light of the facts and circumstances in each case. In United States of America v. Master Builders, 1991 DLT 719, it was observed, if the owner in building contractor terminates the contract and revokes the license, the contractor cannot seek relief to be authorized to continue the work under contract, and court will not that way indirectly grant specific performance of agreement. The owner cannot be forced to continue to employ a contract with whom he is at loggerheads. Similarly, a contractor cannot be forced to work for owner whose contract has been terminated even though wrongfully. As regards the plea of lien, it was observed term lien in its ordinary sense means the right by law to keep possession of something belonging to a person in debt until that debt has been paid. Lien cannot give any right, interest or title in the immovable property in possession of person claiming lien. In view of above discussion, the plaintiff B is entitled to an ad interim injunction directing A to remove himself from property and further not to resist or obstruct the entry of B plaintiff thereto. Facts of present case have been drawn from case Master Builders v. United States of America 1991 DLT 719. Q. 77B filed a suit for dissolution of partnership and accounts against A. In order to deprive B of the benefits, A began to shift the goods and assets of business establishment in a hurry. Advise B as to what should he do in the circumstances. Ans. Section 94, D, and Order 40 of the Code of Civil Procedure deals with the appointment of receivers. According to it, the courts are empowered in certain circumstances to appoint receivers. It provides that where it appears to the court to be just and convenient, the court may by order A. Appoint a receiver of any property, whether before or after decree. B. Remove any person from the possession or custody of the property. C. Commit the same to the possession, custody or management of the receiver, and D. Confer upon the receiver all such powers as to bringing and defending suits and for the realization, management, protection, preservation and improvement of the property, the collection of the rents and profits thereof, the application and disposal of such rents and profits, and the execution of documents as the owner himself has, or such of these powers as the court thinks fit. In Krishan Kumar v. Grindlays Bank AIR 1991 SC 899, it was observed, following principles must be borne in mind before a receiver is appointed by court. A. The appointment of receiver is a discretionary power of court. B. The object of appointment of receiver is the preservation of property in dispute pending judicial determination of rights of parties to it. C. A receiver should not be appointed unless the plaintiff prima facie proves that he has very excellent chance of succeeding in the suit. D. Since appointment of receiver deprives the opposite party the possession of property before final judgment is pronounced, it should only be granted for prevention of manifest injury or wrong. In Issal Das S. Lulla v. SMT Hari, AIR 1960 to Madras 458, it was held that the appointment of receiver is in the discretion of the court, and the court should not exercise the power as a matter of course, but only when it is necessary to do so. A receiver should not be appointed when there is a bona fide possession of the property, unless there is some cogent grounds for interference. The main object and purpose of the appointment of receivers is the preservation of the subject matter of the litigation pending a judicial determination of the rights of the parties thereto. Q. 78. A. Can a court appoint a receiver in a case even without an application from the party concerned? What is the duration of the appointment of a receiver? B. Can a receiver be appointed in the following cases? I. In execution of a decree in respect of a compulsory deposit in the provident fund due to the judgment debtor. 2. In a suit for enforcement of simple mortgage on the application of the mortgagee. Ans. A. Appointment without application. According to the provision of Order 40, Rule 1 of the Code of the Civil Procedure, a court can appoint a receiver in a case even without an application from the party concerned if it is satisfied that it would be just and convenient to do so. According to those provisions, it is not necessary that the appointment should be made only when the application is made. Duration. No provision has been made in the Code of the Civil Procedure regarding the duration of appointment of receiver. The Supreme Court has summarized the law on this point in Hira Lal Patni v. Loon Karan Sethia, AIR 1962 SC 21, has observed. I. If a receiver is appointed in a suit until judgment, the appointment is brought to an end by the judgment. 2. If a receiver is appointed in a suit without his tenure being expressly defined, he will continue to be receiver till he is discharged. 3. But after the final disposal of the suit as between the parties to the litigation, the receiver's functions are terminated. He would still be answerable to the court as its officer till he is finally discharged. 4. The court has ample power to continue the receiver even after the final decree if the exigencies of the case so required. Ans. B. I. A receiver cannot be appointed in execution of a decree in respect of a compulsory deposit in a provident fund to the judgment debtor, as held by Ahobiali Supreme Court in Union of India v. Hira Devi and another, AIR 1952 SC 765. In this case, the decree holder, a lady, had obtained a money decree against one Ram Grahit Singh, a retired head clerk in the dead letter office. In 1949, a receiver was appointed for collecting the money standing to the credit of the judgment debater in the Provident Fund with the postal authorities. The Union of India intervened for setting aside the order of appointment of receiver, and the Hobbieli Supreme Court allowing the appeal of Union of India held that no receiver can be appointed and such a deposit cannot be assigned or charged and is not liable to any attachment. 2. It has been held in several cases that a receiver can be appointed even where the mortgage is a simple mortgage, but the Hobbieli High Courts of Allahabad and Patna have taken a contrary view. The view in Charan Nandi Chaudhary v. Rajneet Prasad, AIR 1932 Patna 360 appears to be correct in view of Sub-Rule 2 of Rule 1 of Order 40 of the Code of Civil Procedure, which lays down that nothing in this rule shall authorize the court to remove. In the case of simple mortgage, the plaintiff gets a decree for sale, and he has no present right to be in possession of the property, and, therefore, the defendant's possession cannot be taken away by the appointment of the receiver. Q. 79. What are the powers of a civil court in regard to the appointment of a commissioner? Has a court inherent powers under Section 151 CR.P.C. to appoint a commissioner? Ans. Appointment of Commissioner. Sections 75 to 78 Order 26 of the Code of Civil Procedure lays down the provisions relating to commissions. According to the provisions of Sections 75 and 76 of the Code, the court may issue commission in the following cases to any person or to court other than a high court. I. For examination of witness. 2. For local investigation. 3. To examine accounts. 4. To make a partition. V. To hold a scientific, technical or expert investigation. 6. To conduct sale of properties which is subject to speedy and natural decay and which is in the custody of the court pending the determination of the suit. 7. To perform any ministerial act. Order 26 Rule 1 of the Code of Civil Procedure deals with the cases in which the court may issue commission to examine witnesses. It provides that any court may in any suit issue a commission for the examination on interrogatories or otherwise of any person resident within the local limits of its jurisdiction who is exempted under this code from attending the court or who is from sickness or infirmity unable to attend it. Provided that a commission for examination on interrogatories shall not be issued unless the court, for reasons to be recorded, thinks it necessary so to do. Rule 4 of the Order XXVI of the Code of Civil Procedure further lays down that any court may in any suit issue a commission for the examination on interrogatories or otherwise of a. Any person resident beyond the local limits of its jurisdiction. B. Any person who is about to leave such limits before the date on which he is required to be examined in court, and C. Any person in the service of the government who cannot, in the opinion of the court, attend without detriment to the public service. Provided that where, under Rule 19 of Order 16, a person cannot be ordered to attend a court in person, a commission shall be issued for his examination if his evidence is considered necessary in the interests of justice. Provided further that a commission for examination of such person on interrogatories shall not be issued unless the court, for reasons to be recorded, thinks it necessary so to do. Rule 9 of Order 26 of the Code of Civil Procedure deals with the commission to make local investigation. It provides that in any suit in which the court deems a local investigation to be requisite or proper for the purpose of elucidating any matter in dispute, or of ascertaining the market value of any property, or the amount of any masonry profits of damages of annual net profits, the court may issue a commission to such person as it thinks fit, directing him to make such investigation and to report thereon to the court. Rule 10- of Order 26 of the Code of Civil Procedure deals with the commission for scientific investigation and Rule 10-B of that order deals with the commission for performance of a ministerial act. Rule 10-A provides that where any question arising in a suit involves any scientific investigation which cannot, in opinion of the court, be conveniently conducted before to the court may, if it thinks it necessary or expedient in the interests of justice so to do, issue a commission to such person as it thinks fit, directing him to inquire into such question and report thereon the court. Rule 10-B provides that where any question arising in a suit involves the performance of any ministerial act which cannot, in the opinion of the court, be conveniently performed before the court may, if, for reasons to be recorded, it is of opinion that it is necessary or expedient in the interests of justice so to do, issue a commission to such person as it thinks fit, directing him to perform that ministerial act and report thereon to the court. Rule 11 of Order 26 of the Code of Civil Procedure deals with the commission to examine or adjust, and its Rule 13 deals with the commission to make partition of immovable property. Appointment of commissioner under inherent powers. A court has no inherent powers under Section 151 of the Code of Civil Procedure to appoint a commissioner because inherent powers are not over substantive rights. Our Hobieli Supreme Court has held in Padam Sen v. State of UP, AIR 1961 SC-18, that a court has no inherent powers under Section 151 CPC to appoint a commissioner to seize account books in the possession of the plaintiff upon an application by the defendant that he has apprehension that they would be tampered with. It was observed by the Hobieli Supreme Court that powers saved by Section 151 CPC are not powers over substantive rights which a litigant possesses. A party has full right over his account books and a court cannot seize them forcibly. It can summon them and, if not produced, it can penalize the party and draw adverse presumption against him. Q.A.T. Unless a right of appeal is clearly given by statute, it does not exist. Comment: can an appellate court reverse the decree on the ground of misjoinder of parties? Ans. Right of appeal is not a natural or inherent right attaching to litigation. Such a right is given by the statute or by the rules having the force of statute. Section 96 of the Code of Civil Procedure provides that, save as where otherwise expressly provided in body of this code or by any other law for the time being in force, an appeal shall lie from every decree passed by any court exercising original jurisdiction to the court authorized to hear appeals from the decisions of such court. An appeal may lie from an original decree passed ex parte. The following are the exceptions. 1. No appeal shall lie from a decree passed by the court with the consent of parties. 2. No appeal shall lie, except on a question of law, from a decree in any suit of the nature cognizable by courts of small causes, when the amount or value of the subject matter of the original suit does not exceed 3,000 rupees. Note: in view of CPC, Amendment, Act, 1999 in subsection 4 of Section 96, now in place of words 3,000 rupees the words 10,000 rupees have been substituted. 3. Where any party, aggrieved by a preliminary decree passed after the commencement of this code does not appeal from such decree. Kinds of appeal. Appeals can be divided into following 4 classes according to the provisions of the Code of Civil Procedure. I. Appeals from original decree. Sections 96 to 99 and Order 41 CPC. 2. Second appeals. Sections 100 to 103 and Order 40 to CPC. 3. Appeals from orders. Section 104 to 106 and Order 43 CPC. 4. Appeals to the Supreme Court. Section is 109 and Order 45 CPC. Appeals from original decree. Section 96 provides that save where otherwise expressly provided in the body of this code or by any other law for the time being in force, an appeal shall lie from every decree passed by any court exercising original jurisdiction to the court authorized to hear appeals from the decisions of such court. An appeal may lie from original decree passed ex parte, but no appeal shall lie from a decree passed by the court with the consent of the parties. Subsection 4 of Section 96 CPC, which has been added by Amendment Act No. 104 of 1976, also lays down that no appeal shall lie, except on a question of law, from a decree in any suit of the nature cognizable by courts of small causes, when the amount or value of the subject matter of the original suit does not exceed 10,000 rupees. Section 97 of the Code of Civil Procedure deals with appeal from final decree where no appeal is preferred against preliminary decree, and Section 98 provides that where an appeal is heard by a bench of 2 or more judges, the appeal shall be decided in accordance with the opinion of such judges or of the majority, if any, of such judges. Second appeal. Section 100 of the Code of Civil Procedure lays down that save as otherwise expressly provided in the body of this code or by any other law for the time being in force, an appeal shall lie to the High Court from every decree passed in appeal by any court subordinate to the High Court, if the High Court is satisfied that the case involves a substantial question of law. 2. An appeal may lie under this section from an appeal. 1. Decree passed ex parte. 3. In an appeal under this section, the memorandum of an appeal shall precisely state the substantial question of law in the appeal. 4. Where the High Court is satisfied that a substantial question of law is involved in any case, it shall formulate that question. The appeal shall be heard on the question so formulated, and the respondent shall, at the hearing of the appeal, be allowed to argue that the case does not involve such question, provided that nothing in this subsection shall be deemed to take away or abridge the power of the court to hear, for reasons to be recorded, the appeal on any other substantial question of law. Section 101 of CPC lays down that no second appeal shall lie except on the ground stated above, and Sections 100-A and 102 CPC provide that in certain cases no second appeal lies. Order 42 deals with procedure to be adopted in second appeal. Civil Procedure Code, Amendment, Act, 2002 has inserted Section 100A which provides no further appeal in certain cases notwithstanding anything contained in any letters patent for any High Court or in any other instrument having the force of law or in any other law for the time being in force where any appeal from an original or appellate decree or order is heard or decided by a single judge of High Court, no further appeal shall lie from the judgment and decree of such single judge. By single judge of High Court, no further appeal shall lie from judgment, decision or order of such single judge. Section 102 of Code has also been substituted by Amendment Act 2002 which says Section 102 no second appeal shall lie from any decree, when amount or value of subject matter of original suit does not exceed 25,000 rupees. Recently, 3 judges bench of Supreme Court in Santosh Hazari v. Purushottam Tiwari by L. Rupees, AIR 2001 SC 965, observed that Section 100 of Code as amended in 1976 restricts the jurisdiction of High Court to hear the second appeal only on substantial question of law involved in the case. An obligation is cast upon the appellant to precisely state in Memorandum of Appeal the substantial question of law involved in appeal for which appellant proposes to urge before High Court. High Court must be satisfied that a substantial question of law is involved in the case, and such question has to be formulated by High Court. At the hearing of appeal, the scope of hearing is circumscribed by the question so formulated by High Court. Respondent is at liberty to show that question formulated by High Court is not involved in the case. However, High Court's power to hear the appeal on any other substantial question of law not earlier formulated by it is not taken away subject to twin conditions being satisfied. A. The High Court feels that the case involves such question, and B. High Court records reasons for such satisfaction. The phrase substantial question of law means question of law which must be debatable, not previously settled by law of land or binding precedent, and must have material bearing on the decision of the case, if answered either way, insofar as the rights of parties before it are concerned. Appeals from Orders Section 104 and Order 43 of the Code of Civil Procedure deals with such orders from which appeal lies. According to it, an appeal shall lie from the following orders, and save as otherwise expressly provided in the body of the Code or by any law for the time being in force, and from no other orders. I. An order under Section 35. 2. An order under Section 91 or 92 refusing leave to institute a suit of the nature referred to in Sections 91 and 92, as the case may be. 3. An order under any provision of code imposing a fine or directing the arrest or detention in the civil prison of any person except where such arrest or detention is in execution of a decree. 4. Any order made under rules from which an appeal is expressly allowed. Provided that no appeal lies against any order under Section 35-a save on the ground that no order or an order for payment of a less amount ought to have been made. Appeal to Supreme Court Section 109 of Code of Civil Procedure lays down that subject to provisions in Chapters 4 and V of the Constitution, and such rules as may from time to time be made by the Supreme Court regarding appeals from the courts of India, and to provisions hereinafter contained, an appeal shall rise to Supreme Court from any judgment, decree or final order in a civil proceeding of High Court, if the High Court certifies I. That the case involves a substantial question of law of general importance, and 2. That the opinion of the High Court on said question needs to be decided by Supreme Court. Order 45C.P.C deals with procedure in appeal before Supreme Court. Whether appellate court can reverse a decree on ground of misjoinder of parties. Section 99 of the Code provides no decree to be reversed or modified for error or irregularity not affecting merits or jurisdiction. No decree shall be reversed or substantially varied, nor shall any case be remanded in appeal on account of any misjoinder or non-joinder of parties or causes of action, or any error, defect or irregularity in any proceedings in the suit, not affecting the merits of the case or the jurisdiction of the court, provided that nothing in this section shall apply to non-joinder of a necessary party. Thus, the appellate court shall not reverse a decree on the ground of misjoinder of parties unless it has affected the merits of the case or the jurisdiction of the court, or there has been a failure of justice. Q. 81 state the circumstances in which a person aggrieved by the judgment of the court may apply for review of its judgment. Ans. In simple words, review means to look once again. In legal parlance, review is a judicial re-examination of the case by same court. Section 114 of Code of Civil Procedure gives a substantive right of review, and Order 47 provides the procedure. Therefore, Section 114 of Code says any person considering aggrieved a. by a decree or order from which an appeal is allowed but from which no appeal has been preferred. b. by decree or order from which no appeal is allowed. c. by a decision on reference by court of small cause. May apply for review of judgment to court which passed the decree or made the order, and the court may make such order thereon as it think fit. Grounds. Order 47 Rule 1 of Code says that application for review of judgment may be made on any of the following grounds. a. Discovery of new and important matter or evidence, which after the exercise of due diligence was not within his knowledge or could not be produced at the time when the decree was passed or made. b. Mistake or error, apparent on the face of record. c. Any other sufficient reason. Explanation. The fact that the decision on a question of law on which judgment of the court is based has been reversed or modified by subsequent decision of a superior court in any other case shall not be a ground for the review of such judgment. Power of review should not, however, be confused with appellate power, which enables the court to correct all errors committed by subordinate court. In A.T. Sharma v. A.P. Sharma A. 1979, SC 104, it was observed. As a general rule, where a litigant obtained a judgment in a court, he is by law entitled not to be deprived of fruits thereof without solid grounds. It is very easy for party who has lost the case to see the weak points in case and try to fill in the gaps by procuring evidence which will strengthen that weak part of his case. Object of review is neither to enable the court to write a second judgment nor to give second inning to a party who has lost the battle because of his own negligence. Q. 82 Can revision be filed against an order of court disallowing an important question put to a witness? Ans. Section 115 of the Code of Civil Procedure deals with the revisional jurisdiction of the High Court. It provides that the High Court may call for the record of any case which has been decided by any court subordinate to such court, and in which no appeal lies thereto, and if such subordinate court appears, a. to have exercised jurisdiction not vested in it by law, or b. to have failed to exercise a jurisdiction so vested, or c. to have acted in the exercise of its jurisdiction illegally or with material irregularity. The High Court may make such order in the case as it thinks fit. Provided that the High Court shall not, under this section, vary or reverse any order made, or any order deciding an issue, in the course of a suit or other proceeding except where a. the order, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or other proceeding, or b. the order, if allowed to stand, would occasion a failure of justice or cause irreparable injury to the party against whom it was made. Subsection 2 of Section 115 CPC further lays down that the High Court shall not under this section vary or reverse any decree or order against which an appeal lies either to the High Court or to any court subordinate thereto. Explanation in this section. The expression any case which has been decided includes any order made, or any order deciding an issue, in the course of a suit or other proceeding. Civil Procedure Code, Amendment, Act, 1999 has substituted the proviso to subsection 1 of Section 115 of Code by following words. Provided that High Court shall not, under this section vary or reverse any order made or any order deciding an issue, in course of a suit or other proceedings except where the order, if it had been made in favor of party applying for revision, would have finally disposed of the suit or other proceedings. Amendment Act 1999 has also inserted subsection 3 to Section 115 of Civil Procedure Code, which provides as under. A revision shall not operate as a stay of suit or other proceeding before the court, except where such suit or other proceeding is stayed by the High Court. Supreme Court in Baldev Das v. Filmiston Distributors, AIR 1970 SC 406 has held that case may be said to have been decided if the court adjudicates for the purpose of the suit some right or obligation of parties in controversy. Explanation added to Section 115 of Code-wide Amendment Act 1976 makes it clear that expression case decided includes any order made or any order deciding an issue in the course of a suit or other proceeding. In view of above discussion, it is clear that order allowing or disallowing a question to a witness is not case decided. Therefore, such an order cannot be challenged in revision. In Prem Bakshi and other v. Dharamdev, AIR 2002 SC 559 application for amendment of plaint was filed to bring to notice of court the subsequent facts application allowed by trial court. High Court set aside that order in revision. When matter went in Supreme Court, while relying upon judgment of Major S.S. Khanna's case AIR 1964 SC 497, it was observed. The proviso to subsection 1 of Section 115 puts a restriction on power of High Court inasmuch as it shall not under Section 115 CPC vary or reverse any order made or any order deciding a issue in course of a suit or other proceedings except where I. The order made would have finally disposed of the suit or other proceedings or 2. Said order would occasion failure of justice or cause irreparable injury to party against whom it is made. Order in question by which the amendment was allowed could not be said to have finally disposed of the case. It is almost inconceivable how mere amendment of pleadings could possibly cause failure of justice or irreparable injury to any party. Thus, order of High Court was held to be outside the purview of revisional jurisdiction. Q83 distinguish between appeal review and reference and revision. Ans. I. Revision and appeal. There are following main distinctions between revision and appeal. A. An appeal lies to a superior court from every original decree unless expressly barred, while a revision lies only in the cases mentioned in Section 115 CPC and to the High Court only. B. The revisional jurisdiction can also be exercised suo motu, while appellate jurisdiction cannot be exercised suo motu. C. The exercise of the revisional power is entirely discretionary, and ordinarily High Court thus take a technical view so as to interfere in every case, while right of appeal is a substantive right given by statute, and every appeal is to be decided according to law. D. The High Court or the revisional court cannot, in exercise of its revisional powers, set aside the findings of facts of subordinate courts, but a court of appeal can do so. D. An appeal abates if the legal representative of the deceased are not brought on record within the time allowed by law, while a revision may not abate, and the High Court has a right to bring the proper parties before the court at any time. 2. Revision and review. There are the following distinctions between revision and review. A. The power of revision is exercised by the High Court and in some cases by the District Court, i.e. the Superior Court, while the power of review is exercised by the court which passed the decree or order. B. The power of revision is conferred on the High Court only and in some cases in some states, on the District Court also, but review can be made by any court which passed the judgment or order. C. Revisional powers can be exercised only in cases in which no appeal lies, but review can be made even when appeal lies to the Supreme Court. D. The grounds on which the powers of revision and review can be exercised are different. The ground for revision relates to jurisdiction, i.e., want of jurisdiction, failure to exercise jurisdiction vested in the court, or illegal or irregular exercise of the jurisdiction, while the grounds for review are the discovery of new and important matter of evidence, some apparent mistake or error on the face of the record, or any other sufficient reason. D. No appeal lies from an order passed in the exercise of revisional jurisdiction while the order following the review application is appealable. 3. Reference and revision. There are the following distinctions between reference and revision. A. In reference, the case is referred to the High Court by a court subordinate to it as provided in Section 113 of the Code of Civil Procedure, while the revision application is moved by the party concerned, or the revisional court can suo motu send for the case and examine the record. B. The ground of reference, the entertainment of some reasonable doubt by the court trying the suit, appeal or executing the decree in respect of a question of law or usage having the force of law, while the ground for revision relates to jurisdiction, i.e., want of jurisdiction, failure to exercise jurisdiction vested in the court or its irregular exercise. 4. Reference and review. There are the following distinctions in reference and review. A. In reference, the subordinate court refers the case to the High Court under Section 113 of the Code of Civil Procedure, while in review an application is made by the aggrieved party in the court which passed the order of judgment. B. The High Court only can decide matters on reference while the power of review is to be exercised by the court which passed the decree or order, as the case may be. C. Reference is made during the pendency of the suit, appeal or execution proceedings, while application for review is made to the court after a decree or order is passed. V. Reference and appeal. A. A right of appeal is a substantive right conferred by law while the power of reference is vested in the court. B. Reference is always made to the High Court, while the appeal is preferred to a superior court which need not necessarily be a High Court. C. The grounds of appeal are wider than the grounds of reference. D. Reference is made in a pending suit, appeal or execution proceedings in order to enable a court to arrive at a correct conclusion, while an appeal is preferred after a decree or appealable order is passed by the court. 6. Review and appeal. There are the following main distinctions between review and appeal. A. An application for review lies to the same court while an appeal lies to a superior court. B. The grounds of review are different from the grounds of appeal. The grounds of appeal are wider than the grounds of review. C. There is no second review provided in the Code of Civil Procedure, while there are provisions for second appeal in certain cases.